Is this the second hearing? All right, give me about 10 minutes. I have Mr. Goodman out here. Malika Robinson. Good morning. Calling case number 2334-8367 LT. I don't know if that's the right. Or no. Is Malika Robinson here? Malika Robinson. Signed in. Okay, that was laid in red where they had the landlord and the tenant. He must have been listed as all occupants. Let's see. Yeah. 8367, yeah, we caught it. All right, let's see. Who else is here? Well, obviously, but. All right, let's get these 830s called. Is Attorney Devlin here? Attorney Wyrock, did you get your case? Attorney Zire? Attorney Doyle? All right, calling case number 2334-8473. This is G-Core Holdings LLC versus all occupants.
Good morning, Your Honor. Attorney Dan Doyle, 37181,
Thank you for your appearance, counsel. Welcome back. I know you've been here. Feels like a walk. All right, your new court date, I do have a deed in the file. Do you know who served this?
Malcolm Jackson.
Jackson served it. All right. And is anyone here from Liberal Street, 16266? Okay. So your new court date will be June 20th, 2023 at 9:30 a.m. Any questions?
No, Your Honor. Thank you. Have a good day.
All right, sir. 473. All right. Mr. Coach.
Yes, Your Honor.
Let's switch sheets.
Okay.
I still have Robert Bolden. I'm gonna call all these first cases and I'll call the addresses out. You're gonna be one of them, so. That's how we'll do that. All right, and then 9:30, I'll call the 9:30s. I wanna get you all out of here for the first hearings as fast as possible. Gerald Dawson. Good morning. Calling case number 2334-7784. Are you scheduled for a second hearing today? Oh, you were on the Zoom about a week ago? Okay, you're scheduled for a second hearing with Mr. Rabbit. Okay, and this is a non-payment of rent case. I'm gonna recall your case because go ahead.
I talked with the manager about the tower. I paid all this coming back.
Well, yeah, we need to wait for the Attorney Rabbit to get here, and then you can negotiate with him, and then I'll call your case again, both sides. First hearings, I don't need both sides. Second hearings, I need both the plaintiff and the attorneys. First hearings, I'm gonna give you all your court dates, allow you all to talk to legal aid, and get you out of here. 7784 is the second hearing. Mr. Dawson is here. All right. 8361, Ms. Kilgore, calling case number 2334831, Alicia Kilgore versus Shquetta Dura. Good. Please approach. Can you state your name for the record? All right, that's your name?
Yep.
Right, today is the date and time for your first hearing.
Well, I had another one, in April, where I had to do the council college.
Okay, so this is yeah. All right, so looks like the case is filed on the 18th. Did you have process service?
Yes, so,
Okay, do you know who served?
Carl Carter.
Okay, all right, so your second hearing date would be June 20th, 2023 at 9:30 a.m. Do you have anything to submit to the court? Try to get in the file or bring it with you on that date instead of submitting it the day before. Just bring it with you. She has to be there for the second hearing. Sure. Default judgment. You get a judgment at the second hearing. If she was here and you worked something out, I would still require a 15-day cushion because everyone's afforded 2 hearings. So if you all want to prevent not coming back and work something in the first hearing, that's fine, but it's still that provision. So I'll see you back on June 20th.
Is it possible to do it with Zoom or?
Person. Do you have to go on like surgery or something?
No, I just, work.
All right, thank you. We can get you a note.
Thank you, sir.
That helps. Well, Breonna Myers, calling case number 233484445. This case was already called. Parties already have their court date of June 20th. Ms. Myers, Mr. or Mrs. Myers? All right. Stanley Butts.
Ready, Your Honor.
All right. Let's call you. What case are you on? Calling case number 2334839, Stanley Butts versus all occupants. And that's all occupants property located at 19150 Berkeley. Is it 141 or 191?
191.
Okay, Berkeley Road.
Yes, sir.
And can you state your name for the record again?
Yes, sir. Stanley Butts.
All right, Mr. Butts. Does anyone live on Berkeley Road? All right, Mr. Butts, do you have a deed?
I do. I don't have it with me, but I do have it.
Please bring it to the second hearing.
Understood.
All right, if you work something out before the second hearing, just know that the negotiations have to start as if from June 20th.
Okay.
Minimum 10 days whenever you're evicting someone by law.
By law.
And because you're afforded 2 hearings, work it out in between, just keep that in mind.
Understood.
That you can't go earlier. Unless they just vacate. So defendant failed to appear, first hearing, you'll bring a deed, second hearing?
Yes, sir.
Okay, and did you get this served?
I did. Marcellus Thomas would have been the process.
Okay. And if you have service at home, bring everything to the second hearing,
Understood.
just in case, so it's no delay. I'll see you back June 20th at 9:30.
All right. Thanks, Judge.
You're welcome.
All right.
Like this. Let's see. Ms. Al-Jabari. Mr. Al-Jabari, I'm sorry. Calling case number 233483346. This is Hyder Al-Jabari versus Jacob Dover. Is Jacob Dover here? All right. Good morning. All right, today's the date, can you state your name for the record?
Huh?
Can you, state your name?
Ain't that a good word?
Thank you, Mr. Altshuler. Today is the date and time, it's the first hearing for a complaint for non-payment of rent. Defendant has failed to appear, however, they are afforded 2 hearings. So defendant has failed to appear, your second court date is June 20th, 2023 at 9:30 a.m.
No.
If you have any documents, make sure you bring them with you, and if you work something out, just consider that extra time that was discussed.
Thank you.
You're welcome. Have a great day. Rachel Moore,
Rachel Moore's right here.
what's your case number, Ms. Moore?
The case number is. The case number is 233-48479.
Here you go. Is Attorney Zara here? Okay, calling case number 233-48479, please step to the front. Ms. Moore. To the podium. Come to the podium. Can you state, good morning, can you state your name for the record?
Rachel Moore.
Thank you. And I'm looking for, here we go. Here we are. Do you reside at the property on Spokane?
Yeah.
All right. Today is the first hearing. You have 2 hearings. Today, and then one on June 20th. I need you back June 20th at 9:30 a.m. Do you have an attorney?
I don't, but I got paperwork. I think you need to see right now.
What's that paperwork that you,
It's very important.
just tell me what it is.
They sent me some paperwork, 2 paperwork, signed, set for delivery. To be back in 36th District, Civil Court, 2024, May 22nd. And this got the same thing on it. It's too bad. I just want to see.
All right, you can,
It's signed.
bring it on around. Bring it on around. And, all right. Hand it to the, can you hand it-
Too, so I think.
Okay, can you hand it to the court officer? Officer Coates to take it and bring it up here. Legal aid is in 417. So if you want to speak to legal aid, they're in
I don't know,
417.
I just got the paperwork and I thought it was best to show you, Judge. That's all I think it was good to do. Show
And I'm-
you.
And I'm going, okay, so this shows that you got service and this is what we have in our file. So that's good. That's good. We have the same document. So go talk to an attorney across the hall. 417. Hard to read this stuff. Sounds hard to read. Okay. 417. You may benefit from going to speak to one and they can help you navigate your case, all right? Well, June 20th, I need you back up. Ready to rock and roll. So we're gonna get ready today. All right. And how are we gonna get ready? We're gonna go to 417. All right, you can come up here. Actually, here he is. Tell him to be. Oh, so he wants to go to 417. Yeah, 417. All right. Can you give me your name one more time, ma'am?
Rachel Moore.
Rachel Moore.
Yes.
All right, Jerome Anderson. Let's Thank you, Ms. Moore. You have a great day.
You too, sir. Amen.
8479. Attorney Coleman,
Yes, sir.
these cases aren't, you have some,
I am Lee Ravis.
you are Lee Rabbit.
One of my many
780 to 784.
Well, he has four phones, Your Honor.
Attorney Abbott, good morning. All right, good morning.
Your Honor,
I'm listening to
Mr.
you.
Ravis has 780,
I'm on it.
781.
I'm already on it. I'm already on it.
I'll be back about.
Please approach and get your files.
I shall, just thank you. Good seeing all you wonderful people again, and God knows how long.
Well, iron clothes this morning.
See what?
You got iron clothes this morning.
Yeah, good morning.
1, 82, 81, 82, 84, 87, 780. Okay. Hold on 1 second. Orange, purple. I'll find it. That's Beverly King.
All right, so, Your Honor, can I call his name, let's see if he was here yet?
Oh, sure.
Good morning, Gary. I'm Attorney Frederick Coleman. If you hear your name, please respond. Is there a Sam second? Is there an Isaac
I
Barker?
can start this one. I'll start.
Is there a Raw Dawson? Let's go. Let's go. This is not. We have a right to see counsel. Let's speak immediately. Yeah, you heard that, you want to. I know you're doing the elk one.
Our counsel, and Attorney Coleman,
Yes, sir.
if you work something out in the first hearing, just add 15 days.
Well, this is something here. So,
But that doesn't apply.
well, you know, I might ask you something nice.
All right.
Somewhat.
Is Attorney Devlin here? Okay. Calling case number 2334-8316, Linden Moose Realty versus all occupants. That property is 17345 Wisconsin Lower.
Brooklyn Road. Good morning, guys. Sabree, my name is
All right, and is this is the first hearing, correct?
Hearing is correct.
All right, you can come up, step up. Good morning, Attorney Abbott.
Oh, Your Honor, good to see you.
Good to see you too. All right, and sir, can you state your name for the record?
Jeremy Dempsey.
Okay, Jeremy Dent.
Yes, DEMPS.
Okay. Good morning, Mr. Dent. All right, it's a little tight in here. You all can work it out. This is the first hearing, which means that we'll be coming back for another one on June 20th at 9:30. You get a notice to appear, but you're here. I know I told you the date, June 20th, 9:30 a.m. If you want legal assistance, they're in 417. If you work something out with Attorney Abbott today, you may not have to come back. But I'm not saying that as an incentive, I'm just saying as a reality, because it'll be worked out. So it's your prerogative, and Attorney Abbott, just consider the 14, 15-day difference, if you work it out today, as if he had a second. That's what I thought. So, all right, you are free to go. 417 if you want to get legal assistance, sir.
Yes.
This is the time to do it. All right, and I'll see you back June 20th. Any questions?
No, Your Honor.
All right.
Late to 417.
Yeah. Y'all talk. I got it.
Well,
All right, that concludes that one. If anybody has a resolution, just pop your hand up. I can see how this can See how people get a bit lost now. Oh. You signed in, I'm gonna call your name. If you're, oh, let me finish calling these names and then we'll address everybody else who's still here. How you doing? Officer. Calling case number 23347389. This is seven, 389. Okay, this is Raven West versus Detrell Johnson. This case is scheduled for 10 a.m. Are you Raven West? Okay, is Detrell Johnson here? Your case is scheduled for 10. I have you checked in, Ms. West. And you may want to check the hallway at 9:30 or something, but well, it is 9:30, but Detrell Johnson. This is second hearing, correct? Okay. I'll recall that 10. And if you see Mr. Johnson, feel free to step out in the hallway and have a conversation. All right, well, feel free if you want to, because that's the only way we'll get a resolution outside of me hearing the case. So if you want to get out of here a little earlier, it might. But any case, you're here. I have you marked in 10 o'clock.
How we do? How we do?
Okay. All right. That's the defendant. That's fine. All right. Yeah, call her. After you're on deck. I'll call you right after I call this case. So you're, yeah, after this. We're getting the logistics together. I'm sorry. You're the plaintiff?
Yes.
Okay, all right.
Yes.
Calling case number 233477784. This is River Towers versus Daryl Dawson and all occupants in unit 420. Is that you, sir?
Yes, sir. Yes, sir.
All right, step on up to the podium. May I have appearances?
To be honest, for the record, Attorney Frederick J. Coleman, P. 56548, on behalf of the plaintiff. I am here on behalf of Attorney Lee Rabbit.
All right, this is a complaint for non-payment of rent. I see parties have worked out a consent agreement. Is that correct?
That is correct, Your
All
Honor.
right.
Daryl Dawson.
Thank you, Mr. Dawson.
Mr. Dawson, you yourself and I'm going to discuss this matter, is that correct? Yes. At this time, we're in for consent agreement, correct? Correct. Agreement is that the amount of $985 paid on before June 22nd. Case is going to be dismissed as the named defendant. Your Honor, as well, we discussed this matter, so the defendant does not have this against his record. We're dismissing after him. MCR 4.201/9 was explained. As stated, I told the defendant he has 3 days from today, days that he's not arrested, he's not an attorney, to file a motion seeking this court to set this aside. It also has 10 days to appeal to a court of higher jurisdiction. That means the conversation.
All right, and our party's okay with this 620.
Your Honor, you can bump it to 6.3. Defendant has some money coming in. He's gonna have basically have to pay by the end of the week. We just want to be sure that he has that additional time. You can change that to 6.3. That gives him that Friday.
This is my issue, and I just want to do it. I don't perceive it being an issue on your end. I just want to stay consistent. If we were to, this is the second hearing.
This is second hearing, not first hearing.
All right, okay, all right. I'm all right with that. Any questions? All right, yeah, you are all set. Well, I just signed this and you can get your copy today.
Your Honor, what I'll do is I'll come back on these other matters roughly around 10:30. Get it before the gentleman is here, and have good time to find out missing files we don't have right now.
Okay.
So you sure they need it?
You're missing, where are you missing? 7780?
Yes.
Okay. Beverly King here? All right. Attorney Clemens, do you have a solution in your mind?
No. I don't
Okay.
think so.
I'll still call it, once we get to. Calling case number 233484338. I'm sorry, strike that. And what's your case number?
233474458.
7458.
Yes.
Calling case number 233474458. This is Ladon Patrick versus Jeffrey Hudson and occupants on 7 miles.
Yes, sir.
Is Jeffrey Hudson here?
No.
Okay, can you state your name for the record?
Ladon Patrick.
Thank you, Ms. Patrick. Is Jeffrey Hudson still residing in Park?
Yes.
All right, and what would you like the court to do today?
Dismiss the case. He paid in full up until July.
Okay, and do you have a dismissal? Have you drafted a dismissal?
No, I just received this in the mail.
Okay, we'll draft it. We'll draft this dismissal today because it's the inaugural in-person hearing day.
Thank
But
you.
I think there's some at the podium, further notice. No, that's not. Oh, all right, well, this matter is dismissed without prejudice. You're free to go. Thank you for coming in and letting us know. All right, have a great day.
Thank you.
Mr. Santiago,
Judge, how are you?
in person.
You're even more current and handsome and just.
Yeah, all right. More considering, more reasonable. Tanisha Davis. I don't see Tanisha Davis on there. You want this one? Hold on. I'm okay? All right. All right, Tania Kennedy. On case number 233484338. Good morning. Take your time. You can say, wherever you're comfortable, you can come to right there if you want to, wherever you want to be. All right, good morning. Doing well, how are you doing?
I'm fine. I'm sorry. I'm so sorry.
You're fine. This is case number 233484338.
Yeah.
Tania Kennedy versus all occupants on Seward Street.
Well, it's Kanaya.
Kanaya.
Yeah, that's
Thank
right.
you. All right. Kanaya Kennedy, Miss Kennedy, can you state your name for the record?
Kanaya 8 Kennedy.
All right, thank you, Miss Kennedy. And is anyone here who lives on Seward Street? 1380, 1382. All right, based on, okay, this is the first hearing in this matter.
Yeah.
This is the first hearing. Parties are entitled to 2 hearings. I will note in the file that defendant failed to appear. This really is a hearing for the defendant to talk to legal counsel and possibly work something out and work a resolution. However, defendant failed to appear. So that,
That really is. Yes, but the reason, because they my aunt owned that place. Okay? And my aunt, she is taking all my money. So I have nothing because I have a base, I have a show 1, 2, 3, 4, 5 years ago. Okay? And I had a business, I had 1, 2, 3, 4, 5 more, but this day 5 business. Because I had a show, I tried to, so I went here. So I put myself, I need help. She took all my money. That didn't help. It did not. And she said, I'm done. She said, you don't need to. I said, okay, that's fine. I'm like,
So do you have a deed to this property?
yeah.
All right, can you present it to the court officer? We're gonna make a copy of that and place it in the file. If it, I think it's is it already in the file? Just in case, okay, I think I have it in the file already. The quick land deed, I have it already. All right, well, you're all prepared and ready to go. I will require you to come back 20th at 9:30, but that day will issue a resolution. You're welcome.
I'm tired. Right now, the reason I was late, their key on my car. Okay. I'm trying to be-
Stay calm, you're doing a good job. You're doing a very good job in doing that. So I appreciate your appearance this morning, Ms. Kennedy, and I'll see you back on the 20th. Just remain calm. In the meantime, you got 2 weeks and a holiday. I'll see you on the 20th.
Your Honor, there's someone else that's entered the waiting room on Zoom. I believe they tried to enter the room.
I've ignored the chime to this point. Attorney Patillo. Good morning.
Yes, good morning, Your Honor.
Are you here for a first or a second hearing?
It technically, I think it would be the first. The first one was April 27th, but the defendant didn't appear at that one. So but the defendant wasn't actually served until May 12th. So this would be considered, I believe, first hearing.
All right, okay. All right, we're in person and I'll set another date today. Is Hubert Bernard here? Okay. And have you, let's see, Attorney Patillo, have you had an opportunity to speak to the occupant of that property?
I have not, Your Honor.
Okay, he's in person in court right now. In your pro. What's going on?
I believe Janetta Fisher from our office.
No, I.
Oh, you come.
Ms. Fisher is representing.
I believe she is, yes, so she's.
Oh, you have attorney? Oh, my phone on. Yeah, because I want you to be able to speak to. You might be the occupant or whoever is listed, maybe represented by counsel. So go check in 417. And I'm going to chat her number. Everything else.
Oh, no, I'll take your wrong phone. I don't even have that phone.
417. Ms. Brady.
Yes.
Shall I send them 417 and check?
So, I just sent Ms. Long to go get Ms. Fisher, but if you want to meet her in the hallway, that works too.
All right, and then you might get a phone call. Okay, Ms. Patillo.
Yes, Your Honor.
I'm going to chat you his telephone number. This is the occupant. I think his father, whose name is on the record, is actually being represented by counsel. But in any case, I think this serves as a better way to communicate right now. So you have his number. I'll type his name in too. All right, and then just we'll figure it out.
So should I call him now, or is Your Honor gonna set another hearing date?
I'll call him now.
Okay,
Call him now, and I'll set another date once you all talk.
Okay,
And
thank you. Your Honor.
I'll figure out if he's represented too.
Okay, thank you.
No problem. All right, plaintiff's attorneys, any plaintiff's attorneys need your file? You need files? All right. I'm not used to giving up files, but that will all change very soon. Naomi Jones. Good morning. 1 second. Zero 7900. All right, is Crump Gibson here?
I'm standing in.
Okay. And did you all have an opportunity to speak?
Yes.
You need a hearing?
I
Okay. Not a problem.
Yes, can I put 6-8?
That's Naomi Jones, 7900. All right, Ms. Jones, are you represented? Okay, and let's see. I'll call you all. Let me see if I can track down. I want to get through at least the rest of these. I'll call these names and you all on that. It's Bertrand Goodwin and Tiffany Thomas. We did that case. Alicia Kilgore and Shaquetta Durr. Did that one. Is Philip McDonald or Charles Dawkins here? Calling case number 2334-8432, Philip McDonald versus Charles Dawkins. No one has appeared yet for this matter. It's scheduled at 8:30. The new court date is June 20th at 8:30 at 9:30 a.m. June 20th at 9:30 a.m. Tania Kennedy, have a great day. And your new court date is June 20th. Attorney Wyrock, calling case number 2334-8458, Vivian Webb versus Lawrence Robinson Bay. Is Lawrence Robinson Bay here? All right, Attorney Wyrock was here earlier. I'm sure she received her date, June 20th at 9:30 a.m. Attorney Zara here. Is Remy Latimer here? Is Jeff Liedman here? Jeff Liedman was present earlier. Checked in, received his new court date of June 20th, 2023. You're checking in and who chart is your attorney. If you're Marion Foster, April Holland, Cornell Jackson, or Bianca Johnson, or Wanda Leakhart, or Irene Loving, or Victoria McDonald, or Jewel Mosley, your court date is at June 20th, and I've already sent out your court dates to the opposing counsel. How you doing? See, call. Okay, this is second hearing. Okay. All right. I'm gonna call yours and then I'll call you, Attorney Clinton. So which case? Keep track of this case. Okay, just the thing. You all need these cases. You can tell me when you're ready. Versus me trying to go through here and see who's checked in and we'll figure it out. What's the case number on that, Officer Cover?
For this one, 233477756.
7-7.
He just walked out again and got home. But this is
7756. Are you ready on that case?
Yes, yes.
Okay. And then I'll call you right after, because I know you have a hearing, so that's gonna take a little longer. 233477756. Attorney Clemens, you're on deck.
Good morning, Brian Booker, DC 65 here for the plaintiff. Just a look at the file.
I have, sorry, I've gotten past it.
Ben Christensen for the defendant, 6268.
I predicted you this call.
We're all discovering that about each other. I think I'm shorter than most people.
I thought you were like 6'7". All right, and parties worked out a resolution?
Yeah.
Yes, sir. With the terms on record. if you'd like.
Okay, so
Sure.
Let's see, the rent, $1,390, $150.13 in court costs, for a total of $1,556.13. Defendant to pay rent, $915 before the regular rent, $950 before February 9th of 2023. The plaintiff then agrees to waive late fees for June of this 2023. Court costs to be paid by 7/15/2023. No finding of fact was made to either side. 4A is checked and box 7 is checked.
All right, is that your understanding of the agreement?
That is my understanding.
Both parties have signed it?
We have, and I believe we handed it forward to you. Clerk, I don't know if it's made its way in the court file yet.
Yep. All right, well, I can sign it and get back to you today. All right. You're ready on this one as well?
Right.
Okay, all right, that's how I'll know. Getting our system down. All right, sort of into this, I guess wait for your copies. Will you be running copies? Okay, yeah, wait for your copies and you're concluded. This case is concluded, 7756. All right, let's call your other one. Calling case number 233477755, Northtown Homes versus Leon Wright and all occupants.
Good morning once again, as Mr. Wright mentioned, the forward line, which are 665.
Good morning. And can you state your name for the record, sir?
Yeah, right.
Thank you, Mr. Wright. It appears that parties have worked out an agreement. This is a complaint for non-payment of rent. It looks like parties you've agreed to pay $11,039.13. $1,139.13 by Thursday, June 15th, 2023. This is the second hearing, correct?
That's right.
Okay. Do you have any questions?
No.
All right. No money judgment is entered at this time. Defendant may be liable for money damages if there's a hole in the wall or missing pipes or something. And acceptance of partial payment will not prevent the court. So 1100 won't do it, 1139. Technically, they'll have a right to evict if it's short. I'm going to sign this judgment today. Good luck, Mr. Wright, and feel free to go.
Thank you very much.
Make sure you get your copy.
I'll just a couple names to see if I got.
Sure. Attorney Clemens?
Is there Ricky Harmon?
Yeah.
Ricky Harmon? Tomorrow? Tomorrow? Jerome Anderson? Jerome Anderson?
Who are you standing in for?
May I ask me?
Absolutely.
Is there a Miss Lee Smith?
Real comes now. Yes, sir. Thank you. Just come back and get it. We appreciate it. Thank you, sir.
Parties in the back here. Are you a landlord, sir? Are you you're a defendant? And is this your first hearing? Okay. This is your first hearing. Is this your first hearing, ma'am? If these are your first hearings, Ms. Luan,
Yes, sir.
should we be, your next court date is June 20th. I'll call the case for the record. But just so you all know, your next court date is June 20th at 9:30. And if you want to speak to legal aid, you can do it now. Instead of sitting here listening to hearings and me to just tell you 9:30 on June 20th, you might as well go across the hall. If you want, if that's your desire, is to get legal aid, you might as well do it right now.
I'll talk to you.
Okay. Okay. All right. Well, that doesn't apply to anyone with the second hearing. But first hearing, you want to, you can go across the hall.
Room 417.
417. All right, this is case number 2334790. This is Shariar Howdy versus Naomi Jones and occupants on Mansfield. May I have a case?
Please, the court, yes, my name is Adam, I'm the speaker 772.
Good morning. Good morning, Your Honor. Good morning,
you.
Your Honor.
Good morning.
Praise the Lord. Sir, I would like to, and I know that you're busy, I would like to give you a little background on what happened with me.
Hold on. Ma'am, are you on, do you reside on Mansfield?
Excuse me, sir?
Do you reside on Mansfield?
No, sir, I'm on Longacre.
What's your case number?
Let me put my glasses on. My case number is 233-42190, sir.
Are you Miss Wilson?
Yes, ma'am. Yes, sir.
Okay, Mr. Santiago's gonna give you a call, ma'am.
Excuse me?
Mr. Santiago is going to give you a call, okay? Are you
So
scheduled
I'm not.
for 10 o'clock? Okay, you're scheduled for 10 o'clock. Sit tight. Ma'am,
Yes,
and we'll get to you. We have a few hearings going on right now. So we'll get to you.
Am I?
Just sit tight. Just sit tight. You're all right. You just can't see what's going on because you're on the phone.
So you'll call me?
Mr. Sant, your lawyer will call you.
So my lawyer, so you want me to hang up, sir?
It's whatever you like to do.
So
Can you state your name for the record? All right, Ms. Jones. And how were you made aware to come to this hearing today?
I'm sorry.
Were you, sir? How did you know about this hearing?
I had to speak this last week on my door. Here.
Okay. All right, and this is a complaint for non-payment of rent. Is your rental rate $825? Okay. And how much money is owed, right?
At the time of the judgment, judge was outlining indicated as approximately $9,075 that was owed. That's outstanding.
Okay, judgment was filed, it's like in May. So did you pay June rent?
This is, I never knew, I had an original property management, and the property management has switched over. I tried to contact whoever the property manager was from the last property management gave me. They never responded back, so I never even knew this lady was the owner of the house or anything. Sarah, I have proof of Sarah trying to contact them as well, so Sarah was okay. I never heard anything until this year, so this would be a year of not me knowing who this person is that owns this house.
Okay, so who are you paying this year?
I'm not sure.
Okay, so just, all right, so what's the plan?
I I don't have a problem with, not holding the house hostage. I just don't have any money to give that with the negligence of not knowing. I guess somewhere around the board, the new owner dropped the ball.
Okay, so how much time do you need? How much time are you going?
We're asking for 10 days for this.
You have any kids? Okay. Just want to make sure it's cool. All right, so the court, based on the calendar, statutorily, we could give you minimum until June 15th. I'm willing to give you the June 19th date, which would give you the June 20th, where they could apply for a writ of eviction. That'll give you a little bit more than 10 days, maybe like 15, and then in reality, it'll take a few days to get that eviction through. So hopefully that'll meet you in the middle somewhere. So I'm going to enter judgment by hearing. Is there any objection to a removal of the named party? It's totally up to you, counsel.
Oh, removal of the name party, no objection.
Okay. All right, we're going to enter this judgment as all occupants, whereas all occupants must vacate by June 20th, or a writ of eviction may issue after that date. So council is kind enough to remove your name, so that the judgment will be in all occupants. You get another shot at the apple possibly down the road if you can find some more housing, but all occupants must vacate by June 20th, okay? Unless you pay the $9,075. You can redeem it for $9,075, or you must vacate by June 20th. You have any questions? And can you submit that judgment?
Yes.
All right, well, we're concluded. Good luck, Ms. Jones. Thank you for appearing. Thank you, counsel. You need it? Huh?
You might have already been.
Oh, okay, all right. How you doing? Doing well. All right, we're in person now, so the flow, I'm getting accustomed to the flow because it's not digital. I'm not in total control of the files. Ms. Parat, are you here? Do you have anything ready?
I don't believe so, Your Honor, because Ms. Smith, Lee Smith is not here. Mine's at 10 o'clock.
Okay. All right, counsel. I don't have names anymore hanging on the names under people's faces, so.
Your Honor, I'm here on 10 o'clock for a Callis law case. I called out Ms. Davis, the defendant, she's not here, she hasn't checked it, so, but it's 10 o'clock case.
Okay, Tanisha Davis. All right, when parties are ready, I'll call default an hour after two. Still gonna stick to my hour. When parties are ready, I know you're ready. Submit the judgment, and then I know it's ready, and I can call it. I think that's the best way to go about things. And then Mr. Bouchard, he's not here, but we'll, is Jerome Anderson here? Jerome Anderson? Enter that default, so I can keep you plugging away. You're not waiting on anything. Calling case number 2334-7757. This is Jennings Senior Living versus Jerome Anderson and occupants in Unit 4 on East Jefferson. All right. This matter is dismissed without prejudice. This concludes this case. Good morning, Mr. Horton.
Just pretty great to see you.
See you too.
Got one with you, so I'm just kind of lingering. So.
All right, which one?
She's meeting with legal right now.
Okay.
But for Attorney Schneider.
Okay. And if you have resolutions, I guess now I'll pop them up here. I don't know pull the file, do it that way. If you need the file, let us know.
Sounds good.
I think I'm gonna start post it. These are your files, these are your files, these are your files. I think that's the way to do it.
I agree with you.
Let me know. You all need files? You all right? Just need defendant. Okay, Officer Coach, Dean Coach.
Judge, man, I do need to fill out the judgment. That's fine.
What was your case number? Let's see.
Holly versus Naomi Jones.
7900.
Oh, you have it right there? Here. Oh, sweet. You already didn't finish this one.
Oh, go ahead, take your time. I'm not rushing.
There you go.
By any means, I'm not rushing. This actually is in my stride zone.
All right, can you remind me of your name again? Raven West. 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 Let's see. Calling case number 2334-7389. This is Raven West versus Latrell Johnson.
Hello.
Hello. Can you state your name for the record?
Latrell Johnson.
All right. And Ms. West, can you state your name for the record?
Raven West.
All right, thank you. And we are a little tight for space, so it's fine. All right, Ms. West, do you own a property at 12911 Hayes?
Yes.
All right, and hold on 1 second. And Ms. Johnson, do you reside at property at 12911 Hayes?
Yes, sir.
Okay. I do have proof of service from Court Officer Fred Dixon. This is a complaint for non-payment of rent. All right. What is your rental rate?
$750.
All right, and what is the last payment you've made?
January 1st, 2021. Yeah.
Is that accurate?
Yeah.
January 1st, 2021.
Yes.
It's been a minute since you paid some rent. Why haven't you been paying rent?
Because the guy that I did the verbal agreement with, he got murdered.
I'm sorry.
He got murdered February 2021. Her aunt is my property manager who collects my rent from her. No. Ella take, I have I have all the proof.
Okay.
All of the
All right,
proof.
so it's not really.
I just met her last year.
Well, nobody.
I met her in 2021. I have the
Hold on,
proof.
hold on, hold on,
Messages.
hold on. This is, if you all want to argue, you all can go to Madison and argue.
I don't want to argue.
All right,
I'm not
good.
here for-
We're in court, and I'm gonna solve this. Just y'all came to the court for a resolution.
Okay.
Well, you did, at least, and so there's some rent owed.
Yes, yes.
How much rent is owed?
Over 20,000 now.
Town's complaint is 18750. So let's see, this complaint was filed at the beginning of May. We want to add 750 to the.
Excuse me, Judge. She's one of the 3 people that came forward after he passed that said, they came forward, nobody showed me a deed, nobody came with a lease or ID. She was one of the 3 people. LSA did show up there to get money. Coco, somebody named Coco, she did show up to get money. Nobody was willing to show me the ID and a deed. I had to find out from legal aid from the last court date that she actually owned the house. When she told me she would bring it back to me when I did meet her, she
All
told
right,
me.
so was the money escrow?
No, it wasn't because the house is falling apart. The roof is down. I have 3 kids. The house is falling. I was saving it and I was willing to work with her at first when she showed up, but she wouldn't show me proof. And I just found out on the 5th from the legal aid that she really do own the home.
All right, so sounds like. Okay. When are you planning on making a payment?
No, I'm planning on moving.
All right, when can you vacate?
Can we do 10 days? 10 days, please.
Yeah. Can you give me 30 days? I have a kid with autism and I have 3 kids altogether. This just came about 2 weeks ago. She would have been to the report if she came 3
Please,
years
please,
ago.
why? No. We're gonna do a judgment by hearing. I'm gonna give you till June 20th, 2023. Vacate. After that date, a writ of eviction can issue. It's almost, yeah. So that should give you enough time. School is out.
Judge, I was in the process of owning this house. I'm doing the buyback program and everything. I'm in touch with the land bank. They couldn't.
How are you in the process of owning a house that the land bank doesn't own?
Because they've been in contact with me because they couldn't get in contact with her. I paid for the inspections and everything. She abandoned the house.
She didn't abandon the house. She's suing you for rent. For
Yeah, of course.
$20,000 worth of rent.
Your Honor, can I say
3 years
something?
later. 3 years. Why
Can I
would she
say
do
There's
something,
no
Your Honor?
statute of limitations. The statute of limitations didn't run.
This lady calls to Detroit Land Bank. I have proof. She
Ms.
changed
Johnson,
the
Ms.
contact,
Johnson,
Ms. Johnson called Detroit Land Bank and changed the contact information for them to contact her. I have proof.
It doesn't
I have
matter. This
proof.
matter is concluded June 20th, 2023. A writ of eviction can issue. After that, you have a legal right to come in here and apply for a writ of eviction. You all remain civil in the meantime.
Thank you.
And don't present any other issues. Good luck with your children.
And Judge, can you tell her to please stop showing to the house? Please. It's becoming harassment at this point. She done sent a man to my house also.
So look, do you plan on vacating before June 20th?
I'm out there. I can't go that quick right now. She just appeared. I just found out.
Well,
2 weeks
I
ago.
only ask that because just don't leave the house open to the elements. If you close it, I'm sure you all have each other's telephone numbers.
She blocked me.
We'll call from another number, okay? And you all can figure that out. I'm sure you can figure that out. But just make sure you coordinate return of keys, but June 20th, 2023. The day after that, you can apply for an application of writ of eviction. You will need to submit a judgment to the court. Remember, memorializing this, I'll sign it. Obviously, this isn't a consent agreement, but yeah, good luck to both parties. Sounds like you got a little head start on whatever you have to do, and good luck.
Thank you.
And good luck, Ms. West. So make sure you submit that judgment, and then
Who do I submit it to?
the clerk. I'm gonna have to go. I think there may be some judgment forms. Take advantage of them while they're still there.
Yo, I don't see any. Judgment form.
Judgment form.
Because it's usually like $2, something, but.
There's some of the back.
Our kids don't have no autism, like she applied.
No, this is it. Okay, all right. We got. Let's get a goal right there. Right. Now get that.
Oh.
So, your case number is you have your information?
Can I get a pen?
There you go. All right,
Yes. Okay.
Official words of the street.
Okay.
oh, I need to sign it. I'm waiting on the judge. A hearing. All right, let's see. Morning. Is anyone still here for a first hearing? Ruth Simpson. Call Ruth Simpson. Yeah. Jeremy Demps. Miss Patrick. Lotta Patrick. Leon Wright. Chantel Cox. All right, and good morning. Is anyone handling Attorney Schneider's cases? All right, calling case number 2334789 Frank Acolo versus Chantel Cox. All right, is Frank Ocolo here?
Yeah.
All right.
234.
And we're.
Okay.
I'm sorry,
All right,
2334 7780.
Actually, I can recall this in 10 minutes. If she's not here.
Okay.
We'll do it that way. And if you're here and he shows up, we may just rehear it. Because we are here.
Yeah.
If I penalize him and I'm here at 11 o'clock, what difference does it make?
Yeah.
So, but you can get out of here and have a representative. I'll give you credit for being here. Thank you for being here. But I'll give them until 10:30 to Ms. Cox, you gotta go back to work.
I'll have it on.
Okay. All right, well, sit tight for a minute. Let's see if we can get a resolution.
Your Honor, may I call these last three names? Maybe before the show, just want to make sure no one sees
Go
if they
for
are.
it.
If I call your name, please respond, so I have a moment to talk to you, and see your representation of the process. Is there a satchel, Sandra Satchel? Is there a Isaac Barker? And lastly, is there a Beverly? Now, also check the check-in sheet. I didn't see the name as of right now.
You're over two? Check.
So we're gonna default to 10:30 for adjournment.
That is correct. What is your name? Good morning.
Turner.
Turner. Martine Turner? All right. Well, let me go down the list. But you're not too far down the list. All right. Latrell Johnson? Where'd Latrell Johnson go? Dana Dobbins? Before I call you, let me see what's going on. I might save you a step. 7436. You're scheduled for 10 a.m. with Martine Turner. Okay, bingo. Our party's ready? Okay, I'm called.
The judge.
Calling case. Did someone call me? Oh, that's fine. Calling case number 2334-7436. This is Dana Dobbins versus Martine Turner. All right. This is case number 2334-7436, Dana Dobbins versus Martine Turner. Can you state your name for the record? Thank you. And can you state your name for the record? All right. I can hear you both clearly. We're a little cramped up in here, so well, don't mind being spaced out. It's fine with me. All right. Today is the date and time set for complaint for recovery possession of the property. I do have proof of service. I have a lease agreement. All right, this is pretty straightforward. Is there any ownership issue? Are you contesting that she doesn't own the property? Okay. How much time is needed?
I don't need any days. I'm on everything.
Okay.
It was the harassment that made it, like really quicker. I have all documents on myself and things of trying to push it further, quick. Stay come out, and we have to court there, all that kind of stuff.
Okay, and is this the second hearing? Okay. Let's see. Today is the 5th. That'll put us to the 15th. Do you have children in school?
No.
Are you already moved out?
Yes.
Okay, so let's do 10 days. That's the statutory minimum. Is that all? Does that work for you? Does it work for you?
Yeah, I just want to make sure, because she didn't let me know that she moved, otherwise there really no need to be here.
She doesn't interact with
But-
me.
Hold on 1 second.
But if she is all cleared out, all personal possessions are gone, it's all clear, I just like my keys and the process is done.
That's fine. I've been talking to her really.
Let me ask you a question. Are you moved out?
Yes.
If she were to lock the door, do you have any belongings in there?
No. I want to see what's ever left today.
Okay, so are you all able to remain civil enough to exchange keys?
Yeah, I don't have no issue. I've been staying in her house for 10 years.
You all seem like you have
You know,
a little
we got an issue.
minor issue.
I know that, it's
You know
just,
what I'm saying?
I think she's just uncomfortable with the fact that I like my house back, and it's unfortunate they have to come to this. But I just want to make sure that when she leaves, everything is gone, all people are gone. I'm able to get in there safely and do what I need to do, and then she's moved on with, her life.
She only went back to the violation. I wasn't supposed to be serious
Okay.
because I'm not a family member, as she quoted.
Okay, all right, so this is the thing. dismiss this case and with the notes that plaintiffs can retain full possession of their property. If you're okay with that, then
Yeah, I have my new lease and everything right now. With my
as I enter a judgment, it's just gonna be a judgment.
I like a judge.
Right. It'll be a judgment for defendant must vacate by June 15th. Or writ of eviction can issue. Is there any objection to all occupants judgment?
I like the name.
Okay. All right, so it'll be a judgment by hearing, whereas Martine Turner and all occupants must vacate by June 15th, or writ of eviction can issue. All right, any questions? Technically, you're supposed to be filling this out. I'm gonna fill it out today. And you all can wait for copies today. So make sure you get a copy before you leave. All right, and good luck. Good luck, Ms. Turner. Good luck, Ms. Dawson.
Thank you. I just don't want none of this on my record.
This will be on your record as a judge. But it's the plaintiff's option.
Yeah, but I was already said when she asked me. So for her to file this, it didn't make no sense because I was gonna move with no problem. Like I don't wanna, hold on nobody's property. Anyway, I tried to do it for a contract loan or try to, work there to buy a house. So she's selling it. Which the realtor already told me that she can't sell it. So, whatever.
It's not whatever, but it's up to the plaintiff to decide. And this is technically her case, so
True.
I can't make her. She doesn't want to do. All right, Ms. Turner, you are free to go. I will have this. There will be a copy of this for you. So just wait around in the hallway. We'll get it to you.
Okay.
Thank you. Have a great day. Say you did. What's your case number?
The last one number is 6220.
6220. This is with U.S. Bank Trust?
Yes.
Okay, Mr. Phillips, gotcha.
Yeah, sure.
Calling case number 2334-6220. This is U.S. Bank Trust U.S. Bank Trust National versus Hubert and Dorothy Bernard.
I'm sorry, good morning, Your Honor. Deanne Patillo, P82378 on behalf of U.S. Bank Trust National Association.
All right, and
Good morning, Your Honor. Jenna Fisher with Michigan Legal Services, P72872, representing Byron Bernard. Byron is one of the occupants. Hubert and Dorothy are his parents, and they are deceased.
Okay, sorry for your loss. All right, were parties able to work out some type of resolution?
Yes, Your Honor.
All right.
Yes, we were,
and-
Your Honor.
All right, fantastic. What were the terms for that resolution?
So the terms of the resolution are, there's no judgment at this time. We want to enter it as a consent, or if Your Honor wants to do it after hearing, just that the plaintiff has a right to recover possession of property. And then for 4, the plaintiff can apply for an order evicting the defendant after July 20th, 2023. And if the defendant does not vacate the property, then the plaintiff can apply for a writ after July 21st, 2023.
Okay.
And I believe the attorney of record, Ethan Hill, already submitted a judgment.
All right, if he submitted a judgment, it was likely signed yesterday. I don't have it. Go ahead.
I'm sorry, Your Honor, it wasn't signed. He just submitted a copy. I can fax in what counsel and I agreed to, but if it's in the file, I didn't know if Your Honor just wanted to write the dates on it. But I can fax it to the court.
It is in the file, counsel. I would love to just write the dates on it, but just fax it on over. If you want to
Okay,
you can email it if you want.
Oh, yeah, what's the email?
All right, I'll copy and paste it so I don't type it out wrong.
Okay.
One second. You see it?
Yeah, I do, Your Honor. I will email it right now.
Okay. All right. Well, we're all set. Thank you for your appearance and
Thank you, Your Honor.
thank you, counsel.
Thank you, Your Honor.
Thank you, Your Honor. You all have a good afternoon.
All right. You too. We're in person, counsel.
Okay, thank you.
You're welcome. Anyone has anything ready? Is this Attorney Greenwood? Is Naila, Larry, are you just waiting? Is this the default you're sitting on?
I'm waiting to see if she shows up. We were scheduled for 10:05.
Okay, I'll call defaults an hour after. So if you have to make another trip or visit another courtroom, I'll be here.
Okay, I'll do that. Thank you.
No problem. So I do have your judgment. Thank you. It's here. That helps. Good morning, counsel.
Good morning, how are you doing?
Doing well. All right. Mr. Turner. Gone. Chantel Cox has already finished. You're in good shape. Let's see. Well, we're gonna check on that. We're gonna check on the landlord shortly.
Yeah.
Latrell Johnson. Dana Dobbins. I believe that. You're just waiting on your judgment, correct? Thomas Jackson. Are you a defendant, sir? All right. And is this your first or second hearing?
First time, I'll come back.
Right. He's ready to be called? Okay. I'll call these cases that are ready shortly. Let me figure out what's going on with Mr. Jackson. If this is your first hearing, I can get you out of here and get you to legal aid. Let's see. 7461 with Milton Ferguson. And Mr. Ferguson is here, correct?
Yes, sir.
Did you all have an opportunity to speak?
No.
I suggest, you all wanna have a conversation before I call the case, see if you can work something out? All right, come on, Mr. Jackson. I'll call your case, it's scheduled for 10. Calling case number 2334-7461. This is Milton Ferguson versus Thomas Jackson and all occupants. May I have appearances for the record? Good morning. Good morning.
Good morning.
And you all are you all married?
Yes.
Okay. Thomas Jackson, thank you. And do you reside at the property at 16130 Ashton?
Yes.
All right. And Mr. and Mrs. Ferguson, do you own the property at 16130 Ashton?
Yes.
Okay. I do have proof of service in the file. I'm assuming that you received it because you are here today. This is the second hearing, correct?
This is the first time I've come down. We had a phone hearing, but they postponed it till today.
Okay, so that counts. That was the first hearing, and today is the second hearing. It's a complaint for non-payment of rent. The rental rate is the rental rate still $10.95?
$10.98.
Okay. And is this the total rent on a complaint is $22.40? It's now June. Did you pay June rent?
I gave him $1,600 for last month. So actually all I owe is $600 for last month, and I owe this month. Right now, good.
Is that accurate?
We also have other monies, which is the water bill, earning $1,300. We also have, a light bill for that property, $250. I do have the ticket.
A blight ticket? All right, and utilities, is he required to pay utilities in the lease?
Yes.
And do you have an attached lease? I mean, do you have a lease with you today?
Yes, I do.
Okay. And have you been paying the utilities?
Yeah, we've been, I'll explain it to you. You want me to explain it to you right now? Okay, I wasn't in the property. I just moved back there in February. When we got there in February, he waived February because he was doing work on the house. Well, my son and his wife was living there, and we've been living there since 2016. But everybody got COVID, so I moved out for a while. They got a divorce. They were aware of it. The back money that was paid while they were going through COVID, $17,000 through Siri. We were under the impression that they were going to take care of a possible water bill or whatever else. So once that was done, he started doing the repairs on the house. The roof was leaking, the walls were falling in, started doing the repairs. I came there and said, okay, well, I'm gonna start doing the repairs. I said, okay, fine. So I paid him right after February, but when I got there, it was like the 20th. So I paid him on the 22nd, something like that.
Okay.
So 30 days from there was my timetable on my money stuff. So I paid him again around the 20th. He called and told me, he said, look, this ain't working. I need my money on the 1st. I said, well, look, give me some time and I will ultimately start getting it down closer to the 1st. I just need a little time. I caught COVID. So I told him, look, I'm 2 weeks behind, but I'll try to catch up. I'm gonna do the best I can when I got back up. So last month, I gave him a month and a half, making an effort to show him, I'm not just giving you a month and then staying a month behind, I'm giving you a month and a half now. So I can catch up. He told me, look, I'd rather just save your money and move out. I said, okay, well, that's what I'll do. Then a week later, changes, we talked and said, well, what you want to do? I said, look, I want to give you your money, then I want to catch up, and then we'll go from there. I'll get it down to the 1st. You know, just gotta give me a little time to do it.
What about the water bill?
That's not my water bill. That's not my water bill. He came and showed me this piece of paper here from a water bill. I got my own water bill.
Is the water in your name?
Yes.
And when was it turned over into your name?
Last month. Would have been last month. I got there in February, but it took me a minute to get going. He gave me that, and I was like, I don't even know. I didn't even understand that. He came in front and handed me that bill there.
But didn't you? So when did you begin your tenancy?
I got there February, like the 17th, February 17th, when I came back in. He was
Of what
doing
year?
repairs this year.
Of 2023?
Yeah, that's when I got back. And
When did the tenancy start?
All three of them, his son, his brother-in-law, and himself, and then occupying the property in the lease agreement that in that first page, and it does include the water bill.
At least since 19.
Right, that's how long they've been occupying the property.
Okay.
no, we moved in, what, 15 or 16? When did we move?
Okay, because I just see it, I see an old summons from 2019.
Yeah,
With your
right.
name on it. So this bill is yours. I mean, it looks like it. Because you were occupying the property. I just didn't, if you moved in 2 months ago, then I would say, yeah, all this usage charge wouldn't be on you, but how is it not your responsibility?
Well, they weren't, my son and his daughter and his wife, they weren't even there because of the repairs that needed to be done throughout a whole lot of time. They didn't turn the keys in. So
You might
that's
have,
what he
you
told
might have
me.
had a water leak or something, but, thank you. So rent. Oh, now this wasn't pled in the complaint. But what's the total amount that he's responsible for on that water?
The delinquent rent, as well as the water bill and the flight ticket, to $5,099.
5099. Now, are you willing to give him more time to pay the water bill?
Well, if he's willing to pay it, he already denied it.
No, that's not what I said. I said that when they got the $17,000 from Siri throughout for the rent, lack of rent,
Cover the water bill.
that does not cover the water bill.
Now, did that money, did all the money get applied to back rent?
No. We only got, a portion of what was owed.
What, 80?
We got that, well, I guess it was, well, they only paid up to 15 months.
Okay, well, did 20% get escrow due to
Plus
repair?
the 20%.
Did you count the 20% in your amount? As far as what was owed? Because,
No, we didn't, I didn't.
okay, I want you to credit the 20% because but for repairs being needed, that 20% would have gone to you. See what I'm saying?
It was counted.
So he just said it wasn't counted, that's why.
Oh, I'm sorry.
How much money was paid by Siri?
Siri, like, and nothing was applied to the water bill. This is all back rent. In fact, they didn't pay the total of the back rent. They said they only paid up to 15 months. And I believe he was behind.
All of the repairs has been done.
Right.
I'm just waiting to get,
Repairs are good?
Yeah, he came through.
I just don't want him to be evicted off of solely a water bill. But this is his responsibility, so, but 10 days to pay half a month's rent or a month and a half's rent is much different than 10 days to pay $3 grand plus half a month. See what I'm saying? But you still have to get your water bill paid, so trying to figure it out.
Well, I just got a wastewater bill for $298. So I don't know why they didn't attach it. I don't.
How much is the black ticket?
$250.
So 20,000 was paid out already?
no,
Oh, this is another page.
Maybe she gave me wrong.
On here it says 2240 is due. That's what was put on notice. I don't want to preclude you from being able to collect your utilities though. So, that's a pretty high water bill.
It's extraordinarily high, because when he came over, the When he came over and started doing repairs when I was there.
Is water in your name?
They how somehow put it in my name. I had
That's
no
what I mean.
knowledge.
He's saying, I'm saying, he told me
I
he
had
didn't
no
even know.
knowledge of
He had
water.
no knowledge how the
Of
water bill got in
bill
his
being in
name.
my name.
And I don't know how it got in his name as well. But when they divorced, because they were dealing with managing company, he came over and fixed the leak under the sink because it was leaking profusely under the sink, and he repaired that when I got there.
What it was, Your Honor, the toilets, both toilets was running constantly. They
Okay,
never called me to tell me about the water.
okay, well, that's what that water bill is, obviously.
Well, he came and fixed it once, and then he come back and do little
Mr.
other
Jackson.
work, as far as I know.
Jackson,
Mhm.
did you pay the plaintiff $3,435 and monthly installments of $286?
Pardon me?
Of the total amount stated in condition of dismissal, defendant shall pay directly 34, now this is an old text.
Yeah, he gave,
Terms.
I was given that estimate, and when I told him that I got that estimate, he told me he didn't do that.
All right, where did the $33.95 go? 20% of the Sarah payment of $16,975 went to 36 District Court's escrow. Where is that at?
It's still there. I have, a lead inspection. That's the holdup. For some odd reason, the, office didn't get the report. So I'm going down to find out why they didn't get the report. Gotta go to room 402 open to city council.
Well, this is the first time I'm ever hearing this.
All right, that's fine. So that $33.95, once you do that, then you'll be paid the $33.95.
Correct.
And where is that money being attributed? What amount is that? Is that going? What I'm saying is, did you account for this $4,000 when you were saying what was owed, or is that money to be credited to his account?
No,
No,
that was money they kept back.
they held back from us. This,
So you
we
tell-
were entitled to it.
So you're telling the court that $16,975 was credited to his account,
Right, the fact.
although you only received $13,508.
Correct,
You
correct.
still gave him credit for that
For the other 3,000.
$3,395.
Yeah, we wait with that.
Okay, and do you all have a ledger or anything? Do you keep a ledger?
Copious notes.
Yeah, you got keep a ledger. Cause I don't know, and I'm just basing on what you tell me. If you tell me that was credited.
What do you mean? What does he mean by credit?
Well, 20% is held back and you're not getting credit for it and they're getting awarded it, then they should credit that to your account. If they're saying they did, then.
No, I got nothing credit in my account. In fact, when we spoke.
You don't have a ledger. You just told me.
No, but in fact, I'm talking about when me and him spoke. He came and presented me that $3,000 bill and he said, and I told him then, I said, well, I thought Siri was gonna take care of that. And then he said, okay, well, we need to find out what's going on with it. And we haven't spoken about it
supposed
since.
to take care of that because it was presented.
At the
within
time.
Everything.
Yeah.
I really don't believe that the whole 100% was credited to the account.
Okay, this is what happened. They said, when they had to discuss it, it was a $16,000 supposed to come to me. They gave me 13,000 and Jackson, his son, asked me to waiver the 3,000 that he was supposed to pay. So I agreed to waive it. So he wouldn't have to pay the $3,000. That had nothing to do with the water bill. That had nothing to do with the 80% that was given to me and the 20% that was held back. That had nothing to do with that.
If it has nothing to do with it, then maybe I shouldn't include it in this landlord tenant. Like, you all can keep this separate and I can issue a judgment for what's owed in rent. And then that way you can keep two, because it doesn't sound like it was mixed on a rent roll. And it was pled for through Sarah, but you all didn't get it yet. It's a little messy.
Your Honor, basically that, water bill, right after the fact that Sarah takes it too long. Because they just switched it back to my husband's name, which the house isn't even in his name, it's in my name. So they just, the water company, after they didn't pay the bill, Jackson didn't pay the bill, it automatically, it gave my husband the bill.
Yeah, you read it, right?
Okay, all right. What are the,
Maybe not the time the property to see since then.
how much rent is owed right now?
Rent is owed is, 1749
1749
plus
was plus 250 for court costs?
the blight.
Okay, blight ticket, that's a legitimate ticket.
I've never seen this. I've never seen that. I never got that.
Son, no.
Oh, my son, no, but when did that ticket occur? Over the winter?
Last year.
Last year,
Give them
a year ago?
see it, and then can you hand it to him?
Well, I'm not going to dispute that. It never was that bad, but I wasn't, like I said, I wasn't there. And when I came back, I assured him that I'm not going to a divorce like my son was and several things.
This is what I'm gonna do.
As far as I was concerned, we were working it out.
So you're expecting to get that 20%?
Yes.
All right, I'll get you to do this. I can put this off, you bring me a ledger and all of this, or I can award a judgment today for the amount in rent and court costs, which is total $2,000. And if you have an action, if the water bill still persists, file another action for the water bill, so it's crystal clear, because I really
And
don't.
it gives
feel
us time,
comfortable.
give us time to find out what happened with Siri and everything else, because Sarah, because at that point, Your Honor, I was under.
Hold on. 1 second. We're gonna enter a judgment today. So in the event that this water bill is a little off or something, it still won't be displaced. You still have your rent, but the water bill is to be addressed. You're supposed to be paying the water bill, correct?
Yes.
All right, so pay the water bill. So we're gonna keep these issues separate because it wasn't pled on this complaint. I really don't want to add it to it. This changes everything. So I'm not precluding you from collecting it. But it's in separate, it has to be in a separate action. I'm not including this on it. Wasn't pled in the complaint and it's a little unclear. So I'm awarding you a judgment by hearing. Or you all can agree. If you all agree to this amount, that's fine too, to enter consent, but $1,999 is to be paid by June 15th. Or writ of eviction can issue out.
Your Honor, this was our situation anyway. When I started, when I got back over, I paid him around the 20th. I told him around the 20th, for 30 days from that point.
June 20th.
Then when he called me to say, I needed my money, I understood what he was saying because he's got bills too.
And everybody has a payment cycle and something.
Right, exactly. I understood. I just asked for a little time.
All right, we'll extend it to the 20th. That's after the Juneteenth, it's Father's Day, Juneteenth, and then Tuesday.
So if I could pay him his money from then, I'll be caught up, and then we'll figure out what's going on with this water.
Well, you're gonna pay the water bill. We'll figure out what's going on in the meantime, while you're paying it.
Paying down to 3,000?
Yeah, at least paying down exactly what you used. And it sounds like with the toilet, that's an issue, but somebody's gotta pay it. So better than having to pay it before June 20th.
Okay, but I mean, that Siri that had nothing to do with that. Sarah doesn't have anything to do with it.
I don't know, that's for you to figure out.
And that's what I mean, that's what I was trying to say.
But this court's not gonna figure it out, and you still haven't received the 20 anyway. So take care of that 20, get your money, and then you all figure out, reconcile. If you wanna come back, you can refile on that, but
What actions could be taken for what bill being paid?
I can't give you legal advice. but fifth floor is general civil. So it can be a separate lawsuit just for that, but judgment by hearings, June 20th, 2023, $1,999 is to be paid by June 20th, 2023. Or they can apply for a writ of eviction on June 21st.
Well, I don't have a lease, so I mean, then, you know, when we talk, me and him will talk about it. We'll figure it out. And then, I was planning on paying him, I was planning on paying him anyway, right? But he said, once he told me keep my money and just move, I was like, whoa, and then I gave him.
Look, you can't tell you keep your money, you pay 1,999, you can stay in the property. And then, in the meantime, figure out the water bill.
Okay, I'll find out, I'm gonna get on the phone as soon as I get out of here. I'll find out what's going on, because I told him I was gonna try to find out what was going on with that
You
anyway.
need a judgment though. Okay.
I didn't fill it out because I didn't know.
Yeah, it's a little funky today.
Here.
Yes.
The Sarah case was actually handled by my agency, so I was able to look it up. And they'll need to have someone either reach out to someone from our office or file a motion to get the escrow released, if the escrow wasn't released.
Okay. That's how it seems like that's where you, yeah.
Someone from their office, on their street.
Yeah, what I'll do is
I'm on board.
get that.
All right.
Okay. So somebody will reach out to you because they'll want to, okay.
Yeah. Good. All right. Hello. Seems like. And what was that amount? 1,999? Oh, 1 second.
I'm waiting. It's 11 o'clock, right?
I just wanted to let you know, I am here for Aaron Cox's 9:30 and 10 o'clock cases. I'm back. Thank you.
Yeah, I haven't, and right now the Wi-Fi. So I don't know. But we're gonna ask for a team.
Second, I have one case, one case at 10, so there's no show.
And then, yeah.
Okay.
Retreat.
Yeah.
Let's get more into the.
It's good.
It's not like this one, so. Sir?
Dismissal and. Yeah.
I got you.
All right. Good judgment. I'll get you all out of here, and then these 3 cases I have ready for rabbits, I'll call, and then Attorney Collins and Attorney Farad.
Oh. Recall that matter that I'm on.
That as well. $1,999 is the total. What was the? Said $250 was the.
That's included, you already included.
Okay. To be paid by, what did you say, June 20th? Any signed agreements, please get in writing. Acceptance of a partial payment will not prevent eviction. So 1,900 instead of 1,999, technically.
1999.
Yeah, exactly. No money judgment is issued right now. And I'll leave this up here so you all can. Yeah, the clerk will get you copies after you can enter in the suit. All right, thank you for your patience.
No.
All right, did you get your clerk copy?
No.
Did you? Yep, it's up there.
What? Oh, sorry. No, you're fine.
All right, sorry about that. Let's see, which one is it?
She just brought it up for a second.
Did not fill it out right?
Okay, I have it. Oh, look, it's yours right here. Sign it.
I got
That's the company.
Can you put the rent on here?
Where do we go?
Right here. We'll have a board on how to fill out judgments. Okay, he's Attorney Coleman. Thank you, Attorney Coleman.
You said you're gonna call my screen, right?
Yeah, probably agree. And then we'll go in order. Is anyone just waiting on paperwork to let me know? Calling case number 2334-7782 River Towers versus Isaac Barker.
Your Honor, for the record, Attorney President J. Coleman, 25654. On behalf of the plaintiff, I understand that you're the record that Attorney Rags.
Good deal, thank you, sir.
Thank you very much. Average is 7,800 East Jail Department 1218, City Trustee District Jurisdiction. Total amount owed is $752.
All right, is Isaac Barker here?
Pardon?
Isaac Barker. So I do have proof of service. Have you checked the hallway?
I called the name of the court, but I did not call him hallway. We call him hallway, Judge. What's the name?
No, because the courtroom is empty. No. Courtroom is full, then I would say call in the hallway, but there's no reason why you wouldn't be in the courtroom, so. Default judgment is granted as to. Default judgment is granted in favor of the plaintiff. Isaac Barker failed to appear. $752 must be paid by June 15th, 2023, or writ of eviction may issue. Welcome. Receive a copy today. That is already signed. Calling case number 2334-7780. River Towers versus Beverly King and occupants at unit 209.
Yeah, again, for the record, Attorney Frederick J. Coon, 56548 on behalf of the plaintiff, I'm saying for attorney of record, that being Attorney Radish, is now before the court as a non-payment rent, subject to hearing. Amount owed is $1,949. The court cost fees is $150. Total amount owed is $2,099.
All right. Is Beverly King here?
Your Honor, there is a caller on Zoom. It's in the waiting room. I don't know who it is.
They just drop off.
Yes.
That is, I believe, I don't think it's Beverly King, I think it's the same person that called in earlier.
Okay, I just wanted to make sure the court was aware.
Thank you, aware. Default judgment is granted due to parties' failure to appear. Defendant must vacate by June 15, 2023. Must pay.
I just heard you send Beverly King to 417.
She was here early this morning.
Beverly King was sent 417.
Your Honor, I have listed this Beverly being represented by Eleanor.
Let's pass it,
Which one you want right now?
pass this matter, that's 7780.
So you wait on that?
We're gonna wait on that.
So you got those. All right, you guys let me know who's representing now.
It's just to be covered.
Jack, can I see that file?
Absolutely.
So I can have.
See, I remember when I sent the
There's
boy
something
17.
Oh, I'm sorry. My approach is.
Yes, man.
Leave that protocol together.
Housekeeping question, is there a way we can have a power cord? I don't know, we might have to figure it out later, but I just.
There's nothing out the floor.
We can figure this out later for.
Okay.
Yeah.
Is it one?
There's one right
There's
here.
one right there. I know it was always one. with
And
jury
the
box.
judge, yeah, jury box for sure.
All right, Attorney Brock, let's do it. And then, representative from Attorney College's office, and then, okay, I see you have one. Yeah, we're. Calling case number 233474448, FPP Property Management LLC versus Leah Smith and all occupants at 3831 Waverly.
Anthony Brockner, P 7404, on behalf of the plaintiff. I'm asking for a default judgment this morning. I have made several attempts inside the courtroom and also did call in the hallway. Have not been contacted by Ms. Smith. They don't think Ms. Smith actually showed up at the first hearing either. At this time, we're asking for a default judgment to vacate by the 16th of June.
All right, and this is the second hearing, correct?
Yes, Your Honor. This is the second hearing.
I'll let her in. All right, Ms. Leah Smith here. Your service counsel. Our default judgment is granted. Defendant must vacate by June 16, 2023, or writ of eviction may issue. Let's see, 653. Writ of eviction could be filed on June 20. All right.
Thank you, Your Honor.
You, counsel. And then you're on deck. Calling case number 233474400 LG. This is Town Residents versus Tanisha Davis and all other items.
Good morning, Attorney Ian Morton of Palace Law on behalf of Town Residents 267892.
Good morning. Is Tanisha Davis here? All right, doesn't appear Tanisha Davis is here. Courtroom is empty, so who shouldn't be sitting in the hallway, then
If I may, Ron? Sure, I will advise the court that I did call out in the hallway multiple times before coming in here as well. And when the applicant presented itself, I did call inside.
okay, thank you for letting the court know that. Today is the date and time for the second hearing, correct?
That is correct, Your Honor. The first hearing, according to our records, Ms. Davis did not appear yet.
All right, and it looks like $13,586.50 is due on.
That is correct, Your
All
Honor.
right, defendant, court is going to issue a default judgment for defendant's failure to appear. That amount must be paid by June 15th, 2023, or a writ may issue that following day, which following business day, which would be June 20th, because of the holiday. All right.
I would just like to report the court to need a certificate of service or anything like that.
No, proof of service in the file.
One.
Calling case number 23344-863 LT. This is King 2 versus Brittany Parham and all occupants.
Good morning again, Your Honor. Brian Butcher, P66250. I'm here on behalf of the plaintiff.
Good morning, Ms. Parham.
Subsequent hearing on an unpaid rent case, we have agreed to dismiss this matter. I know that in the dismissal also, Ms. Parham has a 0 balance.
All right, Ms. Parham. Good to have a 0 balance. Thank you for appearing in court today. Thank you for your patience. Let's dismiss this matter. We may never have to see each other again in court. Good luck.
Thank you, Judge.
Thank you. Get a copy for your record. Calling, go ahead.
Could you call the case that I'm on?
Let me call him, yes, one more. Calling case number 2334775, Prince Hall versus Keosha Morrow and all other occupants.
Good morning, once again, Judge. Brian Butcher, P66250. I'm here on behalf of the plaintiff.
Right, is Keosha Morrow here? All right, counsel, it doesn't appear that Ms. Morrow or anyone on Prince Hall Drive, 2125 Prince Hall Drive. There's all attorneys in here. Doesn't look like any defendants are present. Counsel, what would you like this court to do?
This time, this is a subsequent hearing. I request entry of default judgment possession only. The rent to retain possession is $879.17, for a cost of $164.46. The total proposed judgment of $1,043.63.
All right, and that must be paid by June 15, 2023. Written eviction may issue.
Thank you very much, Your Honor.
You are welcome. 7753. Right. That's the line on the docket sheet now. It's more so physical file. Whatever is presented by you all now. Okay, Ms. Braley. Yeah. And then Attorney Greenwood, you're on deck.
Okay, thank you.
You're welcome. All right, and that.
Just to make sure there wasn't an attorney Schneider that checked in this morning.
I didn't see Attorney Schneider check in. I don't have Attorney Schneider on my check-in list.
And Ms. Cox stated that the plaintiff didn't show up for the prior hearing either, but I don't see it.
Okay, yeah, well, let's see what the, hold on one second. My flow is changed.
I can't imagine why.
7892. Our calling case number 2334789 This is Frank Polo versus Chantel Cox and all occupants.
Okay, this is Hillary Braley, P number 8288. I'm here on behalf of Ms. Cox, who is here with us to state the record.
Chantel Cox.
So
Good morning, Ms. Cox, again.
it's good to know that I can still interrupt you in person as opposed to just.
Oh, yeah, it's way more, way easier to predict.
Yeah. Okay, so at this point, Your Honor, given that the plaintiff does not appear to be here and may or may not have shown up for the first hearing either, I would respectfully ask that you dismiss this.
Dismissal without prejudice is granted. From a practical standpoint, are you a renter?
Yes, I am.
All right, just continue to pay your rent. But as it relates to this case is dismissed. So if you owe some rent, pay some rent. If you don't, but you are free to go. Thank you for being so patient.
Do you need me to sign something or?
Well,
Because there's no forms up here, so.
I have something.
Shall I approach?
You may approach.
Okay.
How you doing? You all right? You want to take a 10-minute? All right, let's take a 10-minute break. Hold on. Let's give Mr. Greenwood.
Thank you, Your Honor.
You're welcome. And then we'll take a 10-minute break. More attentive than, okay. Calling case number 2334-3958. This is International Home Sales versus Naila Larry and all occupants at 19463 Farm.
And greetings, Your Honor. Emmett Greenwood on behalf of plaintiff. This is a relationship to property located at 19463 Farm Street. This is a subsequent hearing for non-payment. Right, instead of the 205.
Okay. And is Naila Larry or anyone who resides at 19463 Vaughn? Doesn't appear that anyone is present for that council. Okay, default judgment is granted. Total amount of rent to retain is $1,200 plus $435 and other money due for a total of $1,635.
Oh, that's correct.
And that is to be paid by June 16th, 2023, or writ of eviction can issue thereafter. In this case number, let me make sure. Where is this on? 43958.
Was the agreement and judge intended, which the last hearing you said, come here.
Can you check this? 2334-3958. Jacqueline McClinton, day at 10:05. All right. Present that judgment to our courtroom. Let her know you were here.
Okay, I will. Thank you.
And hopefully that person isn't, you know, any issues, come back here or let her know you were in here.
Okay, I sure will.
Because it's the first day, so things are a little funky.
I know.
All right, we're gonna take, all right, take care, Mr. Greenwood. All right, let's take a 10-minute break and then, you have some defaults?
I do. For cop, no, there's like 4 of them, so I'll come back in 10 minutes for copy of the cases.
That's fine.
Okay.
All right, sounds good.
Everyone needs to take a break, so for this.
Never gets a break. All right, Curtis gets his break. Right around his, sports car.
Oh, it's
He's one of those
Yeah,
guys.
he's one of those guys.
He's probably driving it on the course this weekend, right?
Now that I wish.
That Grand Prix was a little too spread out for me.
It was, oh.
I mean, I didn't go. Bless you. They might have something on their lawn.
Right.
And slap some bleachers as they should have.
I didn't ride this weekend, which I'm bummed about, but a couple of the groups I normally ride with rode down here and kind of took it in for a little bit. Because there are places where you can get right next to the course without having to dig, like, I think along the riverfront. I'll ride the riverfront.
That makes sense. Yeah, it's cool. It's cool.
And it was great weather, so. Well, I'll read the reports. I don't know what the drivers thought of the course, or if there was, because before, when it was in the city, before it went on Belle Isle, they were saying it was really rough, a lot of bouncing. I don't know if it's gotten better or not.
Oh, I'm sure.
Yeah,
I'm
because
sure it's bouncing.
Well, when
All
I'm
these
riding
big
my
trucks.
bike, I'm
Right.
like going like, 15 miles an hour, and it's bumpy.
feel it,
If you're
yeah.
going like 180 on those cars.
Your shoulders are probably just.
Yeah.
Oh, man. Yeah, I'm sorry. This is a good showing. I didn't see it on TV. Did you see it on TV?
No.
Probably made the city look good.
Sorry.
They have never seen anybody driving so fast toward TCF.
Usually you'll see it on the lodge right before they get downtown, people driving that fast, but not.
Yeah, but not that direction.
Yeah,
like-
No, I'm trying to see if I can.
Nice front. Color.
It was somebody.
And I had it.
I can't mute. I'm just talking.
Yes.
I-
Yeah, I mean, I suppose you could listen to it.
Yeah, you gotta go. Or stop talking.
I can't handle paper anymore.
Yeah, right? Yeah, without that, I have one thing left, I signed 400 documents this weekend too, yesterday.
Oh, so your hand is a little cracked up.
No, I mean, my hand is free. Yeah, my hand is free. Curtis's hand is cracked up.
These are different pieces. That's not ours.
He's the boss now.
How about? What did you just say? What did you just say to me? Thank you. That's what I thought you just said.
Yeah, I feel like a judge now.
Did you
DJ.
talk to her? She's a nice mug, by the way, Chris.
Oops. Let me take that away. That's a little too much for, I don't want to fit
Earlier, we've been staring at it all day.
This is Bob.
Okay.
Sorry.
You didn't, I wasn't trying to make you self-conscious. I just thought it was funny.
Thank you.
What do you want, Bill?
Ms. Wilson? Mr. Santiago, your attorney, is trying to call you. He's going to voicemail because you're on Zoom. If you could hang up and answer the phone when Mr. Santiago calls you.
Oh, so you wait.
He would like to speak with you.
Okay. All right.
Okay. Thanks.
Wait for Santiago.
Okay, thanks, good morning.
Yeah, no problem.
Can I just kick
The
her out of
hallway,
Zoom
the
so
hallway
Robert
crazy?
can call?
The hallway acting, it's real calm, huh?
Not as bad as I thought, it was light day today. Lighter.
Yeah, Ms. Wilson?
Previous,
Mr. Santiago is trying to call you, but we can't reach you because.
How you doing over there?
On Zoom on your phone. Please hang up this call.
Oh, yeah.
And Mr. Santiago. will be
How you doing?
calling you.
I'm doing good, how are you?
Good. Are you functioning? Are you able to just, is it working?
It's working all right, yeah.
All right.
Yeah.
So you're on a laptop?
Yeah, I'm on the,
Hillary, should I just remove her from Zoom? Did you tell her?
Was
Or
there a
does she
line at
hear you?
417?
I don't know.
There
Ms.
isn't.
Wilson, I'm going to remove you from Zoom
Just hit miss.
so that Mr.
Now it's in the
Santiago,
highlights.
your attorney, can call you.
We got it.
When you're on the
Cut out a
phone
little
on
bit, but-
Zoom, you
You
can't
with
get through to you.
UCAC?
I will remove you. Wait for
So
Mr.
Michigan Legal
Santiago to
Cert,
call.
are you with UCAC as well?
Yeah.
So how many people are MLS? Who's MLS?
She's MLS.
What's the, is, Santiago MLS?
Yeah, yes,
Okay.
but we all work together.
UCAC and MLS are basically the same
I just
organization,
removed
but
the new ones. Yes, I call them the conjoined twins of legally.
Okay, and then Lakeshore is what? The Green Party? Okay.
Not us.
All right, well.
It's just about being able to.
Just like the old
Yeah.
days. See, Judge
Yeah.
Sabree knows what's up with the boxes.
Yeah, I can't wait to really, came here yesterday, I didn't really set it all the way up, but
Oh, you mean.
I think we'll have the cases ready.
Yeah.
So you all can just
so you can see it.
bring them back up
So you
here.
can see it.
I hear you. It's cute. It's cute.
I search for
Was it a line out there?
Wait, outside or?
417?
Oh,
There's no traffic, really.
No, 417 wasn't horrible. We sent them away. We had them intake sheets and go. For the first hearing pieces. We're doing all that kind of stuff too as well.
Gotcha.
You
gonna be hanging out in my courtroom?
Me? I'm gonna come down today and tomorrow for sure. Had to be here just to see, and then, Kevin's been doing so much of my coverage.
He's gonna show his face and disappear.
I gotta have some FaceTime a little bit. But yeah, I'll probably just keep using Kevin.
I need one of those, Club Rockers and Shake Shack has the little buzzers.
Yeah.
I don't want to, I don't want to.
I need a buzzer system.
There you go. Yeah.
Give him one, call him one. Pork is definitely.
He is, yeah, he's down in 431.
Like a tether. I might give him a real tether.
Yeah. But you could be like Judge Robinson, who just wander the hall and come and like walk in the room.
That works too.
Yeah.
He does it with his roll on?
Yeah.
He's
Got the final say.
Yeah, he used to do that to him.
I will be in.
I believe it.
Yes, but I will need
Yeah, he's
to.
always want to cause stress.
Yeah. Counsel, I need you now.
Okay, all right.
It's a handful.
I'm on my way. Sorry.
Would it mess up your life if we ran an extension cord to the table with the surge protector? There's a surge protector right here. So that we could plug in
I don't think
laptops.
that's a pretty low traffic area.
Okay,
I mean,
I just want to make sure. Because there's an outlet there, but then, it seems like there's one.
yeah.
And there's already cords running to the
That's
podium.
fine, that's fine.
Awesome, thank you.
We should run, and then what we'll do, we'll get something, we'll order something. Like an extension cord, like a brain.
Put in your time. I wish my husband still worked at Shinola, I could get those really pretty ones. Have you ever seen those Shinola extension cords? Yeah. I don't have access anymore. Sample sale, that was great, wasn't it? That was my husband.
I was getting like leather bound gloves.
Just making sure.
Turn over gloves.
Yeah.
Everybody's family has turn over.
Dog vets. Yeah.
Bike wrenches.
Yep.
Yeah,
That was great.
One time ago.
Yeah, he was the
Oh, sweet. So what's he doing?
he is the CEO of American Conservancy. So apparently the family business, I didn't know.
Oh, wait, was that
His
the
job
dude?
is-
He was up here. That was the dude, never mind. He was the dude that the judge. No.
Mary Grove, so that's not the school.
No, that's straight consent.
And so the Mary Grove Conservancy
So
was
five.
bought by charitable organizations.
I know I gave him the paperwork.
And University of Michigan.
I was trying to get my daughter to go to, Scott, right? Is the primary, is the start of the school.
At Mary Grove?
I was a bit academy for 8 years.
Okay.
So I was basically, I was on 6 years.
Okay.
And then looking at babies, you guys got it.
Okay.
So that's my campus.
So what they're doing, they call it a critical career education.
I know I did. I made the email.
Neighborhood, I guess, that's your
I'm in like the secondary.
Okay. Okay.
I don't want you. I don't want you, but if I'm doing.
Okay.
I'm not too far, but
Right.
I'm like that
I'm
secondary.
turning around and proofing it once.
So, but they're working with U of M, so U of M education students can come and work.
Ours is good, Starfish. It's
Yeah.
called Starfish. I know the small kids, they have a beautiful new building.
Yeah, they just built a new building and they're raising right now. Yeah. So that's what he's trying to get.
I wish I didn't have to drive. I had to drive. It's only goes 3 days.
Okay.
But it's
Awesome, thank you, sir.
Our
Appreciate you.
summer starts to teach.
Yeah, good.
She has wanted to be a preschool teacher forever. She's about to teach, but she goes to Butler University in Indianapolis, so she's gonna get licensed in Indiana first.
Hey,
Jingle, are you a basketball fan?
Remember,
We played in
we
Hinkle
got
High.
Super
Did you?
417.
My
She
dad
had
played
came
at
back
IU.
for paperwork.
So Indiana basketball.
Yep. And then, filling in counter when you come back here.
Okay, I'm out. I'm on public. Take care, guys. Good to see you. I did. Take care. It was like Oak Hill and some other these.
Thanks, no problem. Have a great time. All right.
Lawrence North
Okay.
High School. I think it's still out.
It's like a-
Because you can't travel.
Yeah.
In Michigan, you can only travel to Florida and State, so that was the best tournament. But they're very exciting.
Yeah. We took my dad played, my dad's a beach hockey man, so he played high school basketball. And that's where those state championships were.
Chicago.
So
That's like.
very Hammond. It's like a Chicago.
I got you. Yeah, okay.
So that's my mom, my dad's from Chicago, Indiana, my mom's from Highland, Indiana, so, yeah, Indiana. I am a Hoosier. That's why I went to Indiana, because we were told that, my brother and I were told we could IU or anywhere else. that we could. So I actually have my BA and my JD from there, but, our youngest is at IU, is a freshman at IU, child number 3 is, she was a junior at Butler. So we took my dad down, and we took him to Assembly Hall for the Indiana game, and then we took him to Able, and it was like, you know, all of us there. Yeah, basketball.
First time. I don't know.
Little brother. He went to school. Maybe.
Yeah.
But we went to IU for a year.
Okay.
Before, Sampson got booted.
Yeah.
He was on that team. He was one of those freshmen for Eric Gordon and all those guys, and they all transferred out. And, I was helping out Antoine Davis.
Okay.
What's his daddy's name? Coach Davis.
Oh, yeah. I can't remember.
I can't remember his
Yeah.
first name, but he was at U of D.
Okay.
He was at U of D for 5 years. He almost broke the Pete's record.
Well, I'm old enough that I was a freshman last national championship.
I did something.
No, I'm not that old. Steve Alford, Keith Smart, last second shot, 23 from the corner outside.
Okay. Who was the coach? Bobby Knight?
Bob Knight.
Bobby Knight.
Bob Knight. Oh, yeah.
So Bob Knight has 2.
Bob Knight has 3, 76, 80, and 87.
Wow.
Yeah, 76 was the undefeated team.
Bob Knight and Bob Huggins are crazy.
Bob Knight's a little crazy.
Bob Huggins is subtle, but nuts. Nuts, but
Knight was just really old school and didn't adapt.
no, he didn't adapt
He
at
didn't
all.
adapt, and so,
He weirdly he had a fan base too.
oh my gosh.
I
that-
was an author,
What?
successful author. Successful.
Oh,
book
yeah.
writer.
Oh, yes, but he worked with the guy from the what's the newspaper in Bloomington. He worked with it, but, you know, it was sad the way he went out. It's nice that he's back involved again, or at least making appearances. Because basketball in Indiana is such a culture that it's, people that don't grow up there don't understand. They take that team around to high school and they will sell 15,000 tickets for a practice. They just travel around the state, going to different high schools, and they sell out all these huge high school gyms.
We're the only team that beat Lawrence North that year.
That's
Had
awesome.
Greg Oden and Mike Conley,
Okay,
you know. But yeah, those were the glory days. We sold out Bobo Hall. So I'm surprised.
So I took the bar in Breslin, and I had to call my dad during the first grade to say, I think Michigan State has the wrong year on one of their banners, because I'm sure we won the Big Ten that year. And my dad had to talk me down, he said, no, just take the bar.
Take the bar. Like, man.
But they sat me like right in front of this banner, and I'm like, I am sure we won the regular season that year.
That threw me off. I passed the bar in February.
See, I took Illinois, I mean, I took Michigan in July, and my husband, when he proposed, that we moved to Chicago after we got married, so then I took Illinois in February, and passed them both. And then he got his dream job and never left. He got his dream job, he's from Michigan. Yeah, which I'm gonna go talk him into finding sports teams.
Gotcha.
So, yes.
Yeah. That's the dream job.
20 years in the NFL.
Then he went over to the city.
Then he went to Shinola, and then he went, yeah, Tom Jr. There's another Tom that's his dad that works with me.
Gotcha.
So
Okay.
there's the elder and the younger. I'm married to the younger.
Gotcha. Right, better thing.
Yeah. It used to be before we had cell phones that I answer the phone and it would be, okay, are you calling about the water department or are you calling about football? Because you may have the wrong number.
Two separate issues, but.
Yeah.
I know you're calling about one, two.
You're not calling for me.
Like March, I just don't answer the phone. Everybody's, oh man, I have the worst news in the world. My house got foreclosed. I need you. Who doesn't work at the treasurer's office.
Yeah.
And can't do anything right now to solve my problem. Yes, all right. Make sure you fill out that claim of interest. Do you know about that?
Claims of interest? Oh, yeah, I do know about claims of interest.
It's like people are foreclosed right now.
Right.
Fill out their claim of interest. And at least when the property sells. They don't fill that out. They get nothing.
We did that on a case that you adjourned because we're filing a quiet title. So we-
One more.
Okay.
That's what I tell people who get foreclosed. Hey, man, stop the plan. County is selling for you.
Yeah.
Get you a check in 2 years.
I'm slowly learning all these
This
details.
stuff is more dense than they give credit.
It's just a lot of information, and a lot of forms, and a lot of.
I was telling Attorney Murray, I was like, look, man, because kind of showed him a little bit before. I didn't want my law firm to go to waste, so he wasn't my partner, but my stuff too with it. So kind of like this, showed me website.
Mine said 181. You get that one yet? I know 781.
You start using chat.
I got 784 and 782. I don't see it up here.
Always.
Judgment still.
781?
Yeah.
Oh, I'm sitting on the file over here.
Yeah.
Give me a sign.
I'm just
Did I not call it?
You called it. I think, yeah, you called that. That's Sandra Satcher. You called that one. No, we know what we called it. I don't know if you called it or not.
Beverly, that's what, I just got handled this.
Beverly. that
Beverly
was
King,
weird.
Yeah, Beverly
You
King.
adjourned it this morning.
Yeah.
But I just saw a judgment.
No, I
Right,
put a
exactly.
judgment there because I didn't know it was adjourned.
Oh,
Yeah.
she didn't know it was a second hearing.
Right,
I thought it
remember?
was a first
Yes.
hearing.
Yeah.
You
I
are,
put it off to the 20th thinking it was a first hearing.
But
Yes.
then you signed the judgment.
this
Correct.
time?
Yeah.
Oh my God.
Well, we didn't put it on the record.
Okay.
So give me that back. Call both 20 and 21, Jay.
Okay.
I mean, 80 and 81.
I can do it.
You want me
What are-
to, is she gone?
Yes.
Yes.
She gonna come back on the 20th?
Yes.
All right.
I didn't want to, but it's been done already. Mistakes do happen because we were perfect. We did it.
Right. Or maybe we just choose to be here.
Okay, well, let's do 781. Let's put that on the record. And then 780, we'll put it back on the record.
Okay. Calling case number 2334778 River Towers versus Sandra Satchel and occupants at apartment 705.
Your Honor, again, for the record, Attorney Frederick J. Coleman, staying for Attorney of Record, Mr. Rabbit. This matter is a subsequent hearing on a non-payment rent. Amount owed is $422, court cost amount of $150, for a total amount of $572. Loss of default, again, with payment to be made on before June 15th.
Default judgment granted. Sandra Satchel, are you here? Defendant failed to appear. The amount is $572 to redeem this property. And this must be paid by June 15th, 2023. Written eviction may issue. All right.
Now we gotta do the survey. That's why you didn't have to give me hearing.
Now it's all coming together. On case number, recalling case number 233347780. This is River Towers versus Beverly King. And all.
And again, for the record, Attorney President Jay Coleman, 25654 on the applicant. I stand the attorney of record, that attorney being attorney right. This is subsequent hearing, the minor date is adjourned to June 20th.
That is correct.
What time, Judge?
9:30.
Yeah, that is true. It is adjourned until 6:20. She was here, but said it was adjourned, so she had a doctor's.
And that is the court. The court interpreted her case as being a first hearing rather than a second hearing, and I automatically adjourned it. Then went on counsel, but in any case, Attorney Coleman will come back to 20 minutes. Get a resolution.
And Your Honor, if I might, since we've been having trouble getting the files, can I just scan the file on here? I have a little tiny scanner.
Really?
I do. And I can just run everything through.
Okay.
And that way we don't have to send Patrick back to get files.
You have a stapler over there?
Do I have a stapler? I do not have a stapler.
Oh, no, you can put it back in the.
I can put it back in the clips.
Gotcha.
You're in the German form for Ken, we need to put a German form.
Ms. Fisher, you think you need to do it in the German form with Ms. King? Yeah, we did do it on the record.
I'm just asking, I mean, I don't need one. I'm just making sure. Both represented by counsel, so I don't think it's an issue, but, you know, just, you know, I don't know how the court want to do adjournments in the future. Are we gonna we're gonna prepare and provide to the court?
Yeah,
we probably need to put some.
Order. Where's that order form?
Well, you know, what we could probably do is leave some adjournments out here, so that we can prepare those adjournments for dismissals in the court on those days. You guys put some copies out here, so we're doing that way. What's this? That's some old stuff.
Waiver of form and arraignment.
I just have a conditional dismissal order. I'm sorry. I printed out everything.
No, you said we're good right now.
Well, were you at the grammar?
I was.
I was down there for a hot
I thought so.
Then I had to come back in here and sign 400 documents.
Oh, look at you.
That's why I really started. That's how I did it now.
Okay. So I'm looking for attorney.
Yes.
Oh,
Yes,
you know me?
I do,
Okay.
but.
Well, is it for someone upstairs?
It's for something upstairs.
Okay, yeah, right after this. And I think that's the last one.
I hope so.
That's for something like that.
I don't know. I'm here for matters of quality.
Okay. All right. Okay, let's do it. I got to get in here with being in person. Usually I've been relying on people in their hands up on the Zoom. So it's like, all right, what's up? So,
And I'm always gonna wait till last. I'm never gonna interrupt them. Like, all right, I'll just wait.
no, interrupt, please. Where's Coleman's 80K file?
I think,
80, I'm
Okay, you
speaking
have
it right now.
Okay. No worries.
It's not going anywhere.
I know. Number.
0910.
All right, these are your second hearings. So you have 1, 2, 3, 4.
I do, and two of them, one's technically a first hearing, and another one, I need to just.
All right, I'm just gonna order. Calling case number 233478888, Adam Lopez versus all
Attorney Elizabeth Allison, P 82098, for the plaintiff, Your Honor, this is in regards to the subject property of 909 Green in the city of Eastland.
All right, thank you, counsel.
Your Honor, I think this is technically the first hearing, we had adjourned the first one in May for service. So we do have service now, and we're just asking for an adjournment to the second hearing.
All right, how about June 20th at 9:30?
That'll work, Your Honor.
If you get in earlier with the defendant here, obviously, I'll call it. Okay. And Mr. Horton, you know those things that Bud Rogers that you get, or like a shake shack?
What's that?
You know those buzzers that you get?
Yeah.
Shake shack?
Yeah. I need, yeah, I'll give him my phone number out to everybody.
No, that takes too long. Press the button.
I think you dismissed one of my cases, though. Can I get a recall?
Yep, I told him that I will recall it, so it'll just be a rescheduled date versus the resolution today. Okay.
What?
Yeah.
Oh, yeah, sir. Yeah, that was the attorney.
Talk to Ms. Bradley.
Yeah.
I feel like I've been betrayed.
Yeah.
My trusted advisor.
Calling case number 2334789 Sweet Living Inc. versus Robert Bolden.
Attorney Elizabeth Allison, P 82098, for the plaintiff, Your Honor.
All right, did you speak to Robert Bolden?
I did not, Your Honor. I haven't seen him, and I do not believe he appeared at the first hearing.
He was here.
Oh, he was here? He was here today?
He was here today. Is he in the hallway?
Who is this, Your Honor?
Robert Bolden?
Yep, he was here. He was supposed to go to 417, and he said he was going there and coming back. So don't know what happened between the 417.
And I haven't seen him. You know,
They may have a backlog, so we're down to check for some. Robert Bolden.
I'll pass that one. Let's see what's going on with that one, but he was here, so he shouldn't have left.
We're still figuring out the communication.
Absolutely, absolutely. And I don't have a good system yet, checking in. Calling case number 2334747, this is Woodbridge Senior Village versus Bernice Cole and all occupants.
Attorney Elizabeth Allison, P 82098, for the plaintiff, Your Honor.
Thank you. Good morning. And it's Bernice Cole here. All right, counsel.
Your Honor, this is the second hearing. She was served prior to the first hearing, so we're asking for a default judgment, $1,204 in rent, $190 in court costs, bring balance to $1,394. We paid on or before the statutory 10 days, which is June 15th.
All right, fantastic. All right, default judgment is granted. Send it to me, I will sign that. Counsel. And the last case is case number 2334743. This is E&E Capital Management versus United Sparks.
Attorney Elizabeth Ellison, P 82098, for the plaintiff, Your Honor.
Thank you. And it's Ms. Sparks here. It doesn't appear that Ms. Sparks is present right now.
Your Honor, I don't believe there's a proof of service in your file, so I can get you this.
Ms. Sparks, are you present?
He never checked in the intake.
You never checked in? Alright, so Ms. Sparks, you wanna come back on June 20th?
That will work out.
Alright, let's return this for service. That's case ending 7423. Gonna adjourn this to June 20th at 9:30 a.m. Kinda gonna be a cattle call, but we're here, we can get you out of here.
Thank you.
You're welcome. And, okay, and I don't need it. We'll figure out what we'll do with the adjournments. I think I might just have empty, I'll see what forms we have on. I'm thinking out loud. So we're not on the record. That default, should have been default, but I do. Recalling case number 23347896, Sweet Living versus Robert Bolden.
Attorney Elizabeth Ellison, P 18098 for the plaintiff, Your Honor.
Good morning, council. This is case number 896. Sweet Living Inc. versus Robert Bolden. Mr. Bolden was present earlier. He was not told to leave. He did not check in with legal aid down the hall, and counsel is present and prepared to proceed on the case. Counsel, this is a demand for possession for non-payment of rent. How much rent is currently owed?
Your Honor, this is for possession and a money judgment, which we do have personal service on. Rent to retain, Your Honor, is $3,380. Court cost of $245 brings the balance to an owing to $3,625.
That amount is to be paid on or before. Are you seeking the statutory 10 days?
Yes, Your Honor, the 15th.
Okay. I'm gonna do June 16th. I'll give him a few more days. He did come. I'll make that work for something. And so you'll be able to apply for a writ on that 20.
Your Honor, I do have a prepared judgment.
Okay. All right, thanks. And money judgment is granted because you have personal service as stated on the proof of service. Thank you, sir. Officer. This is crazy.
So, Your Honor, I hear we might have to recall something.
Yeah, I think we have a recall in the works. Happening sometimes. I think I said we might have to do it too. All right. Put it out there. Wanda Miller. Listen, oh.
That's our case, Judge.
Calling case number 233400910 LT. This is Wanda Miller versus all occupants at 14227.
Yes. Yes, Your Honor, I'm here.
Michigan Legal Services P57157 on behalf of Clara Wilson, who is on the phone. Ms. Wilson, could you please state your name for the record?
Yes, sir. My name is Clara, C-L-A-R-A, Wilson, W-I-L-S-O-N.
All right, thank you, Ms. Wilson, for your patience. I know you've been waiting around for a while on this one, so we appreciate you.
Sure.
The third hearing in a combination of minutes again was adjourned the second time because whole council became the last hearing maybe in June. Since the last hearing, I had the opportunity to obtain a copy of that document. Also included a copy of the
Judge, at this point, I'm asking for the concern I brought to Ms. Hamud at the prior hearing was that Wanda Miller had dementia. And so she was going to look into it. And today, when she appeared, she had me what she reports to be the power of attorney. I'm not familiar with powers of attorney in New Jersey, which is where that document comes from, but in Michigan, they have to be witnessed. It's simply her daughter and supposedly the signature of her mother. There's no witness signatures or anything. And so at this point, I would question the validity, authenticity of that document. According to Ms. Wilson, when we spoke, Ms. Miller had dementia in February. The date of that power of attorney was March, I believe, 4th of 2023, which is a month after. And again, it was brought to me today after I brought to Ms. Lee my concerns that my understanding Ms. Miller had dementia.
Just in response to that, there are no issues of fact for a file. That's number one. Number two, this doesn't matter for the probate court to decide. This court does not even have the authority to decide whether or not the power of attorney is valid.
I disagree, Judge. First of all, a power of attorney is not a probate matter. A power of attorney can be executed. But again, I have not had the opportunity to research what the laws in New Jersey and Michigan. From my experience, they have to be witnessed because otherwise there's all kinds of problems that would occur if the person who's supposedly handing over their power of attorney is that person and no one witnesses, no one attests to anything. And so I believe those are tribal issues in fact, and I would like the opportunity to at least research what the law is in New Jersey because that's where this document supposedly came from.
All right, so why is the power of attorney so important here?
Excuse me, Judge. Excuse me, Judge. First of all, praise the Lord. Your Honor, what happened, the reason why it even ended up over here, my dad was sick. I didn't know how sick he was. And he called me and told me he was going into the hospital and he needed someone to be here to take care of my stepmother, Miss Wanda, and the dog, his best friend, Shelly Mae. And I came over here and I took care of Miss Wanda. My mother was killed in a car accident, and Miss Wanda was like a mother to me. She loved me, and she knew I loved her. And anything I asked her to do, she would do. And I came here, my dad was in the hospital, and he needed someone here to take care of Miss Wanda, my stepmother, because she was showing early stages of dementia. I came here, and I took care of her. I made sure she ate and changed her underclothes. I put her on clean clothes, and I took care of her because I love her, and I know she loved me. And Your Honor, there's no way in the world that my stepmother would have wanted me out on the street. She treated me like I was her daughter. I love her, and she loved me. And the thing of it was I'm 63-year-old, Your Honor. I'm in poor health myself. I've had 2 hip replacements. I can give you my doctor's name and number where you can verify it. But I love Miss Wanda. That was my stepmother. She still is. And I took care of her. I didn't know anything about dementia. I never even heard of it. But I noticed that she was different from what she was. And that's when my dad said she was in her early stages of dementia. And I took care of her. I did the best I could, Your Honor. And while I was taking care of her, I changed my life over to the Lord 9 years ago. I'm a Christian. I love the Lord. And the Lord loves me. And I know that it would not be Miss Wanda's will for me to be in the streets. She was like a mother to me. And her daughter, Robin, she's the devil. She's the devil. And when my father passed, which I found him, in the bathroom on the floor. Robin never called to give her condolences or anything. What she did was she came here, put a key in the door, walked in, and told me that she was going to change the lock, and she did. And she called the police. When the police came, she told the police that I was squatting. And the police told her if she was squatting, why are you changing the locks? And I showed the police officers my keys. And they told her, ma'am, if you do not give her keys, we are going to take you to jail because what you are doing is illegal. This is a civil matter. You cannot change the locks without an order from the judge. And what hurt me the most is I love my stepmother, and I still love her. And I know she loved me, y'all. Praise the Lord. And I know that there's no way in the world my stepmother would have wanted me on the streets. And the thing of it is, she told me, I was bathing her one day, and we were talking, and she said, Claire, I want you to take care of your daddy. She told me that your life out of her mouth. Praise the Lord. And my stepmother, Miss Wanda, if she was in her right mind, Papa, there's no way that she would have wanted me on the streets. She loved me, and I love her. She was my stepmother, my mother passed, and I still love her. And this is not her. If she was in her right mind, there's no way in the world, sir, that she would have wanted me on the streets. And the reason why I couldn't go back to the apartment that I was in, because they had closed it down, because the apartments had black mold in it. And my stepmother told me, Claire, I want you to take care of your daddy and the dog, Miss Lucille. And it hurts me to my heart because I only met Robin twice in my whole life. I've never done anything to that girl. I didn't know her, and she didn't know me. But I took care of my stepmother. And my daddy, he was,
Miss Wilson.
they were both killed.
Miss Wilson.
And it hurts me to my heart.
I have to stop.
Yeah.
Miss Wilson, I can't stop. I'm going to stop you for a minute and thank you for the information that you provided with the court. I want to make sure
Yes,
that.
sir. Yes, sir.
Okay, so 1 second. I'm going to address. I had to hear what was going on, and I didn't want to miss anything you said. So I'm going to place you on mute briefly as I talk to the attorneys, and then we'll go back on the record. Okay?
Yes, sir.
Okay. All right, we're going to recall this matter shortly. And then we'll go back on the record, ma'am.
Praise the Lord. Praise the Lord. Praise the Lord. And here's the thing. So I accepted Christ in my life 9 years ago. I'm no saint. I wasn't a sinner in one day, and I'm not going to be a saint in one day. But I know for a fact, my stepmother loved me, and I loved her. And it was nothing we wouldn't do for each other. Sir, I didn't know anything about dementia. I didn't know, but I know that she had changed. But I made sure that her and my father, who was in hospice, they had brought a hospital bed here and everything. I made sure that she ate and she changed her underclothes and put on clean clothes, and I love her. And my stepmother loved me. There's nothing she wouldn't do for me. When I lost my mother in a car accident, she was like a mother to me. And she was good to me all the time. And I know that if she was in her right mind, there's no way that she would want to see me on the streets. Your Honor, I've been looking for a place. I'm 63. I'm on a fixed income. I get $914 a month. I get $188 in food stamps. And I'm doing the best I can. And my dad asked me before he passed, he said, I want you to take care of Sally Mae. That was the dog. They were best friends. And when they came and got my stepmother, my father his health just declined because he was hurt and sad that they took Miss Wanda, my stepmother. And so was I, John. And I don't have much money, but I pay the light bill, the water bill, cable bill since I've been here. And I've been looking for a place. God knows I have. I'm just tired. I'm tired, sir. I'm tired. And I'm doing the best I can. Lord, please I am. I get up. I get so much pain, but I go to that bus stop. The Lord shows me. I go to that bus stop.
That's not.
What are you gonna do when you go to mute?
What's that?
What are you gonna do when you don't have mute and everybody's?
I need a gavel.
Gavel?
I don't have a gavel yet. You need one. All right. Are both parties ready on this matter? Okay. Calling case number 22391210 LT. This is Stephen Harris versus Sepia Coffee and all occupants on John R. Now pronounce that first name right.
Good morning,
Thank you so much.
Report Kathleen Sabree on behalf of Stephen here, we found community development.
Morning, Dr. Tree, operating on behalf of Highway 96.
Okay, you're on behalf of Mr. Harris?
That is correct.
Okay. Sure, you're on behalf of
Both defendants, Coffee and Thomas.
okay. Can I have your name, please?
Stephen Harris, Your Honor.
All right, thank you, Mr. Harris. All right. I'll go through the register of action and then I'll let you all just present your arguments.
Thank you.
I know I didn't hear this case originally, so this is Judge Millicent's case. I want to go over it. So if I make any mistakes, you all know and we can correct them as we go. All right? So this case was originally filed.
Your Honor, I'm sorry to interrupt. There's a Ms. Miller that just signed in the Zoom. Is that what this case? Is that this case?
No, that's on our.
Oh, okay.
Okay, she's named now.
No, it's a different Miller.
Okay. So this case was filed September 19th, termination of tenancy case. It was personally served. It's marked in the computer on the 23rd of September. Hearing was adjourned from October 17th to November 7th for the second hearing. Hearings was filed from November 7th. It was adjourned to November 28th. From November 28th to January 23rd. There was another personal service that occurred at that time. There was an affidavit filed on January 13th from Stephen Harris. Evidence was filed, pre-trial was scheduled in front of Judge Davis for February 1st. Answers, immediate pleadings. The plaintiff's answer to defendant's affirmative defenses were filed. Briefs were filed. Brief was placed in the courtroom. Brief in support of breach of contract. Order was granted. Judgment without jury was entered. Order of eviction was filed. Let's see. So judgment was entered where defendant must vacate by May 15, 2023. On May 15, 2023, looks like an order of eviction was filed. Was paid. A motion to stay proceedings was filed and scheduled for, bear with me, May 23rd. And May 30th, it looks like something was, an appeal was filed where the enter without circuit court case number per management. Then case number was placed on appeals in 31st. So you all have been at this for a while. Where are we right now?
Your Honor, if I may.
Absolutely.
A written eviction was executed. The bailiff went to get Mr. Mason based on the writ of execution. And Mr. Mason showed the bailiff court form which his attorney had given to him.
Stephen Mason?
I'm sorry?
Stephen Mason?
Martell.
Okay.
I represent Stephen.
There's
Stephen Harris.
Yeah, Stephen Mason is a court officer too, so I mean.
No. So the bailiff went out to execute the writ. The validly signed writ by Judge Mills. The bailiff was given a court date of June 9th. The bailiff erroneously believed that he could not in fact evict Mr. Mason because the court date was actually pending. So I filed an emergency motion for the execution of the eviction pursuant to defendant's failure to comply with the applicant court was sustained. So what happened, Your Honor? I'll give you the very specific court. MCR 4.201 in 3D is the governing courtroom for appeals for possessory judgment in this court. The filing of the claim of appeal together with, these are key words, a bond or escrow order of the court stays on proceedings, including a writ of eviction, which you cannot execute. So we have three things that the defendant didn't do. And this is why the date of June the 9th should not go forward, as well as a secondary immediate writ of execution should be ordered. MCR 4.201 states specifically that the defendant has 10 days. He has 10 days. On May the 3rd, this honorable court granted the judgment of possession. On May 15th, defendant untimely filed his claim of appeal challenging the judgment. The claim of appeal was filed 12 days after the entry of the judgment. The court rule is clear that you have 10 days, Your Honor, after the entry of the judgment. So technically, my argument can stop here. because he filed it 12 days after the entry of the judgment, meaning it hasn't perfected because it's untimely and he's past his due date. So we'll keep going, Your Honor. On May 18th, defendant filed a motion to stay, which is 15 days past the 10-day deadline pursuant to NCR 4.201. Now, what's also just very important to this case, notwithstanding the fact that defendant filed everything late. So as you stated, Your Honor, we have an opinion written by the judge. We have a very lengthy opinion and order that was written and signed by the judge. We have a writ of execution, but this is just a tactic to buy more time. But when you look at the law states the filing of a claim of appeal together with a bond or escrow order of the court saves all proceedings. Guess what we don't have, Your Honor? We do not have a bond. We do not have an escrow. So you can't even stay the proceedings unless it says together with. This is the plain language. This is the black letter law. They have to be filed together. We don't, one is untimely. Two, we don't have it filed together with the bond or escrow order. And what's also interesting, we don't even have an order or a motion to stay the proceedings properly filed. I have a motion for stay of bond and escrow order pending appeal. How do you stay a bond that's never been ordered? You can't stay something that hasn't been ordered. It says a motion for stay, bond, and or escrow pending appeal. Now, the court rule doesn't say we need a motion and a court date in order to stay an eviction. It says we need a bond paid or an order of escrow. Neither of those things have been attached. Instead, my brother counsel, in his motion for stay of bond, he asked to pay $100, which is a nominal bond. What should have happened is he either A, went to the district court and paid the bond and then did the motion to stay, or B, he did a motion to waive the bond. We don't have a waiver of bond. We don't have a bond paid. We don't have an order of escrow. So again, this filing is not perfected. Again, we don't have a stay. The order of eviction should be executed forthwith. My client has paid for bail, wants to come out. And because the other side says, hey, I have a court date, they couldn't execute. My client has paid for dumpsters. Again, we couldn't execute. My client hasn't received any rent in 1 year. So now he's accruing all of these fees. And the reason I say this is a stall tactic, because this individual, he has another lease that starts in July. Martell Mason has another lease. So all he's trying to do is stall this case out on my client's dime until he can go to his other place in July, which isn't fair because the judge signed a possessory judgment on May 3rd. So without me being redundant, Your Honor, I do have a case law in here. And then in addition, the court rule governing post-judgment motions is 4.210. And that says any post-judgment motion must be filed no later than 10 days after judgment is entered. It doesn't say may, it doesn't say should, it doesn't say could. It said must. My brother counsel did not file his post-judgment within 10 days. It's not valid, it isn't perfected, and the writ should issue forthwith. And then it goes on to say, if the motion challenges a judgment for possession, the court may not grant a stay unless the motion is accompanied by an escrow deposit of 1 month's rent. We don't have that. The court is satisfied that the grounds for relief under MCR 2.612 and the issue of writ waive and the issue and order that waive payment of escrow, such as order by ex parte. We don't have that. We don't have an ex parte order waiving escrow. So, Your Honor, again, it says the defendant's post-judgment motion to stay bond was filed within 15 days after the entry of the judgment on March 3rd. I have it filed with the circuit court, and it's actually filed in the district court. The pending claim of appeal has not been perfected where the defendant untimely filed the appeal, post judgment, and failed to post an appeal bond or post a monthly escrow. As a matter of law, MCR, and I'm just making my record, I know you've heard. As a matter of law, MCR 4.201 required the defendant to pay that monthly escrow. He also failed to do that. And his failure to do all those things, I'm asking for the following relief. I'm asking for execution of writ of eviction. I want attorney fees for having to be here today. And moreover, I would like for the order for the writ of execution to explicitly state that the eviction, which was signed on March 3rd, May 3rd, is forthwith so that the bailiff isn't confused. If the bailiff goes out today, I don't want his client to be able to show that same piece of paper and we keep getting the runaround because the court speaks through its orders. And the only orders in place is an order of possessive judgment in favor of Stephen Harris, and it's an order of writ of eviction in favor of Stephen Harris. That's all.
All right. Thank you. Thank you, Judge. I'm gonna address each of those point by point. The first point regarding the timeliness of the application for appeal. As you know, the order was entered May 3rd, 2023, 10 days. That 10 days from May 3rd was May 13th, which is a Saturday. The next available court date is the 15th, which is the 10-day period that it attributes to, as you well know. Therefore, the filing of the appeal on the 15th was timely. The entry of the order of execution was invalid because it did not allow me to enter that application for appeal within that 10-day period.
When was that entry of, what was the entry of order of eviction?
The order was entered in onto the 15th.
So it was requested in order of everything?
Yes. Okay. So that was done before the 10 days that I was permitted to file the appeal expired. I did file it timely within the allotted time frame because the 10th day fell on a Saturday. There is no requirement that the motion for stay be filed conjointly with the application for appeal. The motion for stay does not have a time frame. Sister counsel relies on MCR 4.201M. However, the application for appeal is MCR 4.201N, which does not have a 10-day requirement for post judgment motions, nor would I argue that this is a post judgment motion. This is a motion for bond. That's not a post judgment motions are, motions for reconsideration, those types of motions. This is a motion for stay for bond. Moreover, it's obviously not improper. I can file a motion for stay in the circuit court. So for the reason that I wouldn't be able to do that, the same thing in district court, other than cold water either. Therefore, I believe that the order was entered erroneously. It was entered before the time allotted to do so. We have a current motion for stay set for this Friday. There's no reason not to move forward with that motion. And I would ask the court to deny plaintiff's ex parte.
Can I say something briefly, Judge?
You clarify one thing. The motion to stay was filed on May 18th.
I believe it was the 17th, right?
I have an 18th.
Okay, go ahead. Thank you, Counsel.
My brother cites absolutely no authority for the proposition that you filed it late instead of early.
What are you talking about?
And he said it was due within 10 days. So if the judgment was entered on May 3rd, and on May 13th was the 10th day, which was a Saturday, he should have filed it on May 12th. The court rule is clear. It has to be filed within 10 days. So all you do is look at the calendar and you say, okay, I have 10 days for May 3rd. May 13th is a Saturday. I filed it on May 12th. You don't file it late, days and days late, because you have a weekend coming. And he has no authority, no legal authority, where I have legal authority. My legal authority states it has to be filed in 10 days. It's undisputed that it has to be filed in 10 days.
Well, the 10 days is business day. That's-
But he doesn't present any case law.
Well, I mean, I do it all day, every day. 10 days is business day. Falls on the weekend, it's going to the next Monday. So that's not even the issue.
So if the Monday was the 15th, he still filed it on the 8th.
Okay, so where we, not even an issue.
It's still untimely. He still didn't file it together with a bond, a waiver of bond, or an escrow,
That's for the motion to stay.
which is required. Yes, and that's what's in front of this court. And see, that's what he is, if you look at, and if I may approach,
So the motion for stay is also a motion for entry of bond. So I mean, an order is required, but I can't make a court move any faster. I entered the motion, and this Friday is the first hearing to get an order for bond.
he could have went paid the bond, or he could have got away with it. That says a motion to stay bond. That still has to be filed within 10 days. That was filed in 18 days. But my point is, the court rule states that he has to file, one, he didn't pay a bond. He could have went down and paid a nominal bond, or he could have asked for a waiver. Today is June the 5th, Judge. On May the 3rd, all he had to do is what I did today. An emergency motion for a waiver of bond, or an ex parte motion for a waiver of bond. And then he would have been in compliance with the court rule. But he didn't do either, and then the motion for stay is outside the time frame, and it's not a motion to stay proceeding, it's a motion to stay bond. So again, it is still A, untimely, and B, he didn't do what was necessary. He didn't, according to the court rule, and I argue that this is post-judgment, because the judgment was entered May 3rd. He did this immediately 15 days following the judgment. So this is a post-judgment motion, and the court rule governing post-judgment motions state, even though it's a bond motion, it's post-judgment. It's essentially a post-judgment motion, and that court rule states post-judgment motions must be filed no later than 10 days after the judgment is entered, and that's 4.201 now. So again, Your Honor, the execution of the writ should be forthwith.
When was the writ executed?
It was filed by sister counsel prematurely, and it was entered by the court.
It was not filed by me prematurely. It was not entered by, I can't make the court enter something prematurely. It was not.
Looking for a copy of the writ that was filed. All right, so the move out date was.
It was 10 days from the entry of the order, which was May 3rd.
So the move out date was
May
May 3rd.
3rd, so 10 days would be.
13th, which was the Saturday.
So 10 days would be the 15th. Right.
So we filed it on the 10th day. Or I was able to file my application.
Your Honor, when I came to the court, I spoke to the supervisor, who told me that this was the 10th day, and that it was in fact proper to file. That was a concern of mine when I went to the desk. I spoke not only to the individual at the desk, I spoke to the supervisor, who said that this was in fact the correct act. It was the TIF act. And then the judge agreed with me, Your Honor. This isn't me making unilateral decisions.
Yeah, you wouldn't have been able to file it if they didn't allow you to file it. That's another thing, so, why shouldn't I issue an escrow order today, counsel?
I have no objection to an escrow order, Judge. I mean, that's
I mean, I'm
essentially
sorry,
what
why
I'm
should
looking
I,
for.
no, that's not, I'm sorry. Why shouldn't I issue an order of eviction today?
Because we have an appeal pending in circuit court
And what day was that, circuit court case filed?
on the 15th of May. Circuit court case actually may have been filed before that. It was sent in to the district court on the 15th. I believe the circuit court case was filed on the 15th.
Well, Your Honor, just the filing of an appeal, and I really want Your Honor to digest this. It's even more untimely without the escrow now. We're here in June. That's the reason you should do the writ of execution. Because he didn't seek to get the escrow order, because he didn't seek to get the bond. That's the reason. You can't come on June 5th for something that was due 20-something days ago. And then Your Honor say, okay, you can enter the escrow. And then my client is still more prejudiced, still not getting any rent. He has a possessory order, he has a writ of execution. He didn't do what he was supposed to do to perfect all of his documents. So if Your Honor did order an escrow, it's still prejudicial to my client because this is something according to the court rule that should have already been done. And that's why on the day that the bailiffs came out, they were wrong for not executing. They were wrong because he didn't file what he was supposed to file. So to give them an opportunity, and my client keep losing money, and not only money, it's been a year.
Judge, that's what the motion on Friday is for an entry of order for bond. I mean, I can't make the court sign the order, I can only file a motion, that's what was done.
Like I said, he could have filed it ex parte, he could have filed an emergency, but again, it's not, he could have paid a bond, he could have paid an escrow. He keeps saying what he couldn't do. The court rule said you can go to that, you can pay it, he could have went to the window downstairs, Judge. And he could have paid it, and that would have perfected it, but he didn't. So don't allow another one of, their errors or their inability to do what's necessary fall on my client who's been holding this property for over a year.
Since the council talks about errors, she filed the writ untimely or prematurely, first of all. Second of all, the court rule states that an order is to be entered by the court to state a proceeding. That's MCR 4.201N. So me just paying the bond isn't gonna do it. I need an order from the court, what the motion is for.
No, Your Honor, it doesn't say that. It says he could pay the bond or an escrow order. Now, again, this is another strong tactic because they're trying to just get to July because they have another place. This is a stall tactic.
All right, I'm going to, I'm going to grant this order of eviction. There's a valid judgment. There's going to be a valid eviction. I don't see any reason to delay it. I really don't see a reason to delay it.
There's a motion on Friday before the presiding judge.
But it's not an order. Court speaks through the order. The last order is clear. They'll keep filing stuff. We wait till then, judge, they just gonna file something else and say, we got another court date. It's a classic stall tactic. I'm sure you're honest.
I'm not gonna call it stall tactic or not, but we're in front of me today, and I'm gonna make a determination and grant the order of eviction.
Your Honor, on the order, can we put something that forthwith or for the bailiffs to know Because I don't want the same thing to happen when he hires, this is a very expensive process. When he pays $1,500, the bailiffs come out, and his client says, no, you can't do it. And because the bailiffs don't know, they like to err on the side of safety. So any language stating that this is forthwith.
Or can be executed.
Notwithstanding a hearing date, a later hearing date.
What's scheduled for Friday?
It is the motion for entry of the order to stay bond, which is going to stay the proceedings.
It's
pursuant to the court rules.
But it's not pursuant to the court rules because he didn't do what was necessary. Like we keep in the necessary time frame.
All right, I'm going to grant an order of eviction. Based on what I've heard, based on the cases to be. Present. Order I'll sign.
Thank you, Your Honor. I'm going to homicide trial across the street, which started 2 minutes ago.
Please present the order and counsel sign.
I'll bring it to 3:45.
Thank you, Mrs. Judy, for your argument.
See what them Santiago.
Ms. Miller? Hold on, we're supposed to. I'm all off. All right. We finish, right? We have one more. How you doing, Curtis?
Oh, good,
Mr.
Judge.
Neville? Good. All right, is this just, were you all able to,
It looks like it was.
Oh.
It's awesome.
Yeah. So it looks like, yeah. I
Okay.
think it should be very brief.
all right, let's do it.
And then I should request my recall them before.
We do.
And that should also be passed. I think we just need a date.
That's true. All right. Okay, recalling case number. Here's the case number.
Please ending in 0910.
Zero 0910.
It's 910. 6910 at the last one.
6910. Thank you. Calling case number, recalling 233469110. This is Wanda Miller versus the occupants at 14227 Long Acre in the city of Detroit.
Good afternoon, Your Honor. Robin Santiago, Commissioner of Services, 35757. Tenant, Claire Wilson, is she still on Zoom?
I don't think so. And Ms. Miller, can you state your name for the record? I think you're still muted. Let's see.
Okay, how about now?
Fantastic. All right, Ms. Miller, can you state your name for the record?
Wanda Miller.
All right, thank you, Ms. Miller, and thank you for your patience. All right, parties are here today for a complaint to recover possession of property. Ms. Miller, are you the owner of 14227 Long Acre?
Yes.
Okay, and did you bring this lawsuit on behalf of your attorney?
Yes, she did. Yes.
Yes. And, okay, thank you for appearing. We are here for termination of tenancy.
Thank you,
Counsel-
sir, for
You're
everything
welcome.
you're doing to help us, because this has been a very stressful situation for our family.
Understood.
And I'm her,
Go ahead.
I'm her
Yeah.
daughter. I'm her oldest daughter. And I work for Homeland Security, Customs and Border
What is
Protection.
what is your name? We just need to know your name.
Robin Mosby, Mosby, and I'm her oldest daughter.
Okay, thank you.
Thank you, sir.
All right. You're welcome for your appearance. Okay, you may proceed, Ms. Moore.
Yes, Your Honor, and with that being said, we are requesting actually a judgment that states the tenants have 2 weeks to vacate the property. As I indicated previously, this was the current hearing in this matter.
Can you hear Ms. Moore?
Yes.
Okay.
This interpretation could have easily been avoided, but as my client has mentioned, they are working for a very difficult time. This has posed a substantial financial burden on them. We are requesting we have a judgment stating that the tenants must vacate in 2 weeks. That puts us at June 21st, June 20th, 2023, and that actually gives them beyond the 10-day time period to put them at June 15th.
Judge, if I may, I'm asking the court for at least 30 days. The tenant is Sarah Wilson, who's 63 years old. She actually vacated her own apartment to move in with Miss Miller, Wanda Miller, and her recently deceased father to help care for both of them. Again, based on the current circumstances, the court certainly has it in their discretion to provide that amount of time. Then I can also try and connect Miss Wilson with other resources to help find housing. Otherwise, we're putting a 63-year-old woman on the streets.
Okay, I think I received an indication on whether or not that would,
Well, that was again from the water.
and okay, let's do this. June 23rd. June 23rd would be right in the middle. June 23rd, we'll get it to until June 26th, which is likely to get it to the end of the month. It's not.
Again, logistically, Judge, this is a 63-year-old woman that has no family. I mean, by the court giving that amount of time, she's guaranteed she's doing it.
How old is the occupant in the property?
She, I believe, is 62. I am 60. She has family in the area. She has 2 sisters that live in different households that she could live with. She has an older sister named Cheryl Wilson. She can live with her.
Mike is the daughter speaking and not Miss Miller.
I don't know.
But Miss Miller is
All right, want to enter a judgment June 23rd.
Judge, my last attempt, would you at least give it the
Ms. Miller,
Yes.
are you willing to give, what's her name?
Clara Wilson.
Clara Wilson until June 30th to vacate the property?
Can we give her until June 23rd?
I was just trying to get Ms. Miller to speak on her own.
All right, go ahead, Mom. Do you want to give her June 23rd? Just say yes.
Yes.
That doesn't, I mean, that has the same effect when you tell them to say yes. June 30th.
Thanks, Judge.
A writ can be applied July 3rd for this property. Writ can be applied July 30th, July 3rd for this property. They'll have close to a month, but this is the final order. You do have a judgment. You all don't have to come back to court. And on July 3rd, Ms. Miller, you can apply for a writ of eviction through your attorney. I made that accommodation for extra time upon defense counsel's request and the consideration for the occupant's age based on the information that was presented. Thank you for appearing, Ms. Miller. That was very helpful in making this determination. Thank you to her daughter, and everyone have a great day.
Thanks,
Thank
Ms.
you,
Miller.
Judge. We appreciate it.
Thanks.
You're welcome. We appreciate you. Thank you, Ms. Miller. If you all didn't show up, we would have had a very difficult time entering this judgment. So your attorney did an excellent job in advocating for you all, but I still don't want to put someone out in 10 days who, based on what I've heard from her attorney, from that, she might have a difficult time. So June 30th, and
Yes,
good
sir.
luck.
Thank you,
You all have
sir.
a great day.
You too.
Thank you.
All right, bye.
Bye-bye.